That is, but I may be allowed for very urgent matter, my lord. Tomorrow. Only.
Motion.
Motion. Obliged.
Hello, this matter, my lord, is already 2022, the tender was putting, my lord. I'm for municipality, my lord. It is already 1 year completed, my lord. So it last petition on 3rd of this month it was listed, my lord. I'm newly engaged, my lord, for respondent, my lord. So matter become on 18, my lord.
On
18, my lord.
18 for what?
18, because my lord is already, it is the term is complete, my lord.
Matter has become infructuous. Or what?
Yes, my lord.
Okay, then not 18, 19th.
19, I'm not here, my lord.
Then 18 Thursday.
Then my lord, the 1st of 2nd of February, my lord.
Okay, 2nd of February. Okay.
May plead your lordship, first I beg to mention for listing of an interrogatory application on 18th, my lord, for modification of honorable.
18 will be difficult, 19th.
And lordship, the repetition is fixed on 22.
22nd. Then we can have it on 22nd?
Lord,
22nd.
I pray for the listing of a request for motion here
Okay, when?
for tomorrow.
May please your lordship, in item number 20, an additional affidavit with regards to the rusty service was filed on 14/12, but the same is not satisfactory.
Get it.
Obliged.
Item number
20.
20. Okay, get it.
Okay.
Right, please, your lord. No, the petition was last listed in the month of August last year. January last week of first week of
What is the subject matter?
My lord, it is pertaining to the Assam Human Rights Commission building. The contractor, though completed and handed over the building to the authorities, but is yet to be made. Notice was issued and thereafter it has not been listed.
When was it last listed?
9/8 to 2020.
Thereafter has not been listed. Okay, on 22nd.
may please your lordship.
May I pray for listing of a case on motion tomorrow, Lord.
May please your lordship. Lordship, I beg to mention item number 21. Lordship, adjournment slip has been circulated.
21.
Yes,
Yes.
lordship, 21.
Oh.
Mr. P.K. Tiwari is not well. He's having short infection.
He's for whom?
Lordship for respondent.
Okay. Otherwise, it's a 16 matter. He's not well. That is the date.
Yes.
We'll consider, but we'll fix the date.
Lordship, after 1st February,
But
2nd
his
February.
name is
may be
not
given.
there in the.
Lordship,
His name is not there in the cause list. 2020.
Lordship, we have
21
engaged-
you are saying, isn't it?
Yes.
It is submitted on behalf of the respondents that Sri P.K. Tiwari, Learned Senior Counsel, has been engaged, who, however, is unwell, full stop, unwell, and accordingly, an adjournment has been sought for, considering that this writ petition is of the year 2016. List on when?
After 1st February, and it,
On 1st.
not 1st, except 1st.
Why
On 6th,
all these days?
on 6th or
Today is only the 12th, 11th. Why all these days? On 29th, 30th?
I am instructed not to fix.
No, it's not
Before first.
instructional. Now we are accommodating you. It's a
And
16 matter.
Please have.
We cannot adjourn till after 2nd. We'll have it on 30th. 30th of January.
Obliged.
31, yes. Sri A.K. Ajad Learned Counsel for the petitioners submits that during the pendency of this petition, the order dated 15/11/2022 passed in WPC 5974 of 2021, which is the subject matter of this contempt petition, has been complied with. Full stop, Considering the aforesaid submission, contempt petition is closed.
Only.
Item 25 subject.
May I please your lordship? May I please your lordship, my lord? This tender has been filed for my lord, my lord. My lord, tender has been, my lord, issued for my lord, hotline, my lord, from the Gormur to Nazira to Gormur, my lord. And earlier 2 times, my lord, tender was called for, my lord. First time, my lord, I was, my lord, technically only my lord bidder who is technically responsive. Second time they called the tender, it was extended 4-5 times, my lord, and I am the sole bidder. Then what happened, my lord? Third time they have called the tender. Your lordship kindly come to the, my lord, and my lord, I along with other bidder has submitted the tender, my lord.
Hmm.
And my lord, as per minutes of the meeting dated, my lord, which was uploaded on my lord 5/1/2020.
5-1?
5/1/2023. 24, my lord, sorry. That was important. Uploaded on 5/1/2024. And your lordship kindly come to the page 150. Decision was 6/12/2023. Page 154, my lord. You wouldn't have 4 or 6. Last page, my lord.
154.
Yes, my lord.
Okay.
Your lordship kindly come, my lord. I'm reading that. Your lordship kindly look to the date 6/12/2023.
Hmm.
And your lordship come to the, my lord, bottom part. 2024 digitally signature, my lord. 1/5.
Hmm.
We came to know on that day, my lord. 5/1/2024.
Okay.
And my lord, the member was present there. The bid submission date was 2011-2002 numbers of bidder were the bidder is Shama Power India Limited, Mega Electrical. Then your lordship kindly come. All the document, technical and financial submitted bidder are found to be generally in order for Shama. The bidder has submitted document establishing experience, Mega Electrical experience, which was failed to meet the experience criteria. As per the bid document.
Specific experience criteria.
Specific experience criteria, my lord. What
Yes.
specific experience criteria? The bid may be considered as a non-responsive. Then your lordship come to page 63, my lord. What is specific experience, my lord? Clause 2.4.2, my lord.
Page
Page 63, my lord.
63.
Yes, my lord. Participation as contractor. Sole
Just a minute, just a minute.
Page
63?
2.4.2. Participation contract.
Yes.
Participation as a contractor, sole partner in JV for lease 1 trunky execution hotline stringing 122 kV or kV transmission line. We have made the experience, my lord. I shall show the document later on. And trunky construction at least 1 of transformer line bay, 1 voltage class or above within 3 years from the date of floating tender, who have been successfully completed. Then your lordship. Then your lordship kindly come to the page 130.
Hmm.
Annexure 4. This certificate issued by them, my lord. Respondent number, my lord. 154, my lord. Page
No,
130.
you say that the findings arrived at by the minutes of meeting held on 6/12/2023 is incorrect.
Completely incorrect, my lord. I saw, my lord, because they will show something, my lord. That is why I mean coming, my lord. Name of supply, stinging of 2 carat, my lord. Annexure 4, page 130, my lord. Name of supply. Sticking of 2 CKT circuit 132 kV Samuguri Kalaigaon line. Name of contractor Mega Electrical. We have, my lord.
Mr. Chaudhary, we need not go to those details.
Yeah, my lord.
Are you contending that for the same contract
Yes, my lord.
which was floated for the first time, you are
Yes.
the only bidder?
Yes, my lord.
Were you, is it for the same contract?
Same contract, my
You
lord.
were found to be technically responsive.
Responsive, my lord.
Where is the document?
Yes, my lord. Yes, my lord. Page my lord.
And even in the second time, you were found to be technically responsive.
Yes, my lord. I'm coming, my lord. 32, my lord. First tender.
Yes,
Page 32, my lord.
yes.
This is first tender. Document are Your lordship kindly read that work, my lord.
Yes.
Page 32. Second circuit work, Nazira, Gormur, in along with construction 2 number 120 line bay, 110 Nazira GSS, 130 Gormur GST, mega electric document are found to be in order.
Mm. Okay.
And B, recommendation.
Mm.
Mega electrical, the techno-commercial bid
Yes.
may be considered as responsive.
Just a minute.
In second tender, we are the sole bidder. Fourth time extended, my lord.
Just a minute. Just hold on, please. So, where is the second?
Your lordship, come to the next page, my lord. This first tender was cancelled, my lord.
Yes.
That 120 kV line identification number is
No,
mentioned.
that is okay. Where is the second evaluation?
Yes,
Second.
my lord. Second evaluation, 34, my lord. 34. There is no tabulation, my lord, because, my lord, it was extended time to time because I am the only bidder, my lord. And there are no 4 or 5 times.
No. Was there any evaluation for the second time also?
No, my lord. Second tender, no, my lord.
Okay. But the first time you were held to be technically responsible.
Responsive.
Yes,
second-
Mr. Kodak.
Yes, my lord. And one thing is that, my lord,
We'll come
important.
back, we'll
One
come-
word has been, hotline has been inserted in the tender, my lord. And that experience I have, my lord. Your lordship kindly come to the 130. My learned senior friend will say this, my lord.
What
One
is,
page 138, my lord.
what he'll say, how do you know?
I am coming, my lord, that is. I have a stinging power conductor test.
Now we'll come back to you, Mr.
Yes,
Kotak. Let Mr. Kotak respond. Yes.
Hello, first tender was cancelled.
Now, first was cancelled because he was the sole bidder.
No. Three bidders.
No, his bid was held to be responsive.
Maybe.
Nevertheless, first was cancelled,
Cancelled.
but he was
Cancelled
found to be
no.
technically responsive.
But technically responsive, they are bidders. Fine with. But third tender, this is in this tender method, there is a clause. The experience clause, he failed to meet.
Where is their experience clause?
Experience clause is page 63.
63.
Yes.
Yes, that we have already said, specific.
Yeah, the execution of trunky contract.
Yes.
And
Yes.
let us have a look on the experience certificate.
Yes.
That's not the trunky.
What is it?
Your Lordship, can you have a look at page 130?
130.
Yes.
Yes.
Name of supply. It's a supply. Work is name of supply. Clause 3.
Oh. Yes.
Has you got?
Yes.
It's not trunky. First of all. And execution of a trunky contract. Your Lordship fully aware of what is trunky method. Right from designing to the end. Everything included.
Three. Participation as contractor for at least one turnkey execution of hotline stringing. One turnkey or hotline stringing. You see the expressions you have used.
And method. There are
No.
and.
First
First participation in a trunky.
First is that participation as a contractor for at least one turnkey execution or hotline stringing of 132 kV
Yes.
or above kV or above kV transmission, and both will be required. You are correct. Turnkey construction of at least one number of transformer or line bay. Where is that experience? This transformer, is it there?
That is in 130 million page.
130 is the stringing.
Only. That's the certificate.
152, my
152.
yes, sir. In respect of line.
Central Organization for Railway Erection has completed the work of transmission of line. No construction of KV. B extension. Yes, what about 152? B extension is there.
Only thing that there is no trunking method. It's
No,
not
no,
a
no.
work of trunking method. Had it
No.
been trunking method certificate, I don't have, we cannot actually
No, no,
reject it.
even in the second requirement,
Yes, method.
and
And
after and it's
No, the-
what is the requirement? Turnkey
trunking
construct-
construction.
construction of at least one number of transformer or line bay.
Yes, method.
Now here at 152, what has been stated? This is to certify that so-and-so has completed the work of construction of 132 kV transmission line from so-and-so to so-and-so, along with construction of 132 kV bay extension. So-and-so, value so-and-so, mega electricity completed entire works. Entire supervisor AGCL.
Difference
What is the stage now?
No, difference only that they are raising the point that it's not a trunky work. And that's the difficulty, what nowadays is all work are trunky work. Right from, you have to complete it from the design to and hotline. Hotline, what hotline? I inquired it, what is hotline? Hotline means one line is live, you have to execute the other line. Hotline is not there.
Hotline is there, my lord, 138 page.
Oh, 1 second. 138. 32.
Hmm? Hotline stinging. दादा एमडी केस दिया ना नहीं तक कुछ एमडी तो दिल इनपुट केस है ना क्या एकदम
What is the stage, Mr. Kotak?
Work order is
No, what is the stage now?
stage, at a stage of issuing work order.
You had already evaluated the financial bids.
Yes.
Huh? Don't issue the work order. We'll examine this. If you are harping on the point that he does not have the experience of a turnkey, let him, you file it on affidavit. If he can satisfy the court, if he's not able to satisfy the court that the experience certificates which you have annexed does not even, and you are correct, turnkey starts from the starting till the end. The entire project is handed over to you from the starting till the end, and you have to give it back.
Yeah.
Okay. Heard.
From design to the lane.
Heard. Sri NNB Chaudhary, Learned Counsel for the petitioner. Full stop. The grievance of the petitioner is against the decision. It's against the action of the respondent authorities in holding the bid of the petitioner to be non-responsive. Full stop. It is submitted that pursuant to our notice inviting tender dated 10/10/2023, the petitioner along with others had submitted its bid. Full stop. It is further submitted that the work was intended to be done earlier, and on the first occasion, the tender process was cancelled, in which not only the petitioner had participated, but was also found to be technically responsive. Full stop. Thereafter, a fresh tender notice was issued, in which it was only the petitioner who had submitted the bid, and after extending the same for more than one occasions, comma, the same was not brought to any logical conclusion. And thereafter, the present NIT has been issued on 10/10/2023, full stop. With regard to the minutes of meeting dated 6/12/2023, by which the bid of the petitioner has been held to be non-responsive and has been communicated to the petitioner via communication dated 5/1/2024, comma, the respondent has held the petitioner to be non-responsive on the ground that the petitioner does not meet the specific experience under clause 2.4.2 of the contract of the tender document. Full stop. The learned counsel has, however, demonstrated by documents that such findings are erroneous, as the documents would show that the petitioner fulfills all the requirements to be technically responsive. Full stop. Para. Per contra, comma, no, appearing for the AEGCL, comma, Sri S. Kotoki, comma, the learned standing counsel has submitted that the responsiveness has to be examined from the point of view of the work in question, and the work pertains to a turnkey project, and therefore experience of similar nature has been sought for. Full stop. Para. The matter would require some deliberation. Full stop. Para. Let notice be issued, returnable on. We give a date. These matters we don't like to delay. Please give a date.
I don't know.
How much time can you
I'll find it with
within 2 weeks? Can we fix on 7th of February? Is it okay? On 7th of February 2024, Sri Kotoki, the learned standing counsel, AEGCL accepts notice on behalf of respondables 1, 2, 3, and 4. Let extra copies by tomorrow. Steps for service of notice upon the respondable 5 be taken by registered post with AD. Steps by tomorrow. Para. Heard the learned counsel on the interim prayer. Full stop. Para. Prima facie, comma, the decision to exclude the petitioner from the purview of consideration appears to be erroneous. Full stop. Accordingly, comma, it is directed that till the next date fixed, comma, the work in question should not be allotted. No work order should be allotted for the work in question. Para. Since this order has been passed at the motion stage, comma, the official respondents as well as the private respondent 5 may come up for modification, alteration, comma, if so advised.
Item 2.
My lord, I call him my lord, but his son is not come. Can it be fixed immediately after Bihu, my lord? Because the CA preparation report, my lord, that I need to file a additional petition. some documents are sent.
But documents would emphasize show that it's a roller floor mill.
Exactly, my lord, roller floor mill and floor mill.
Yes.
The GM, my lord, he has, my lord, sent the proposal, my lord. GM after inspection
No,
and
even your
consideration.
project report would
Project
suggest,
report she has prepared and it is a mistake, my lord, typographical mistake.
no,
roller
not
floor.
in one page.
But
Not
there
in
are
one
some,
page, in various documents, including the equipments which you'll be using in the floor mill.
at
you have
give me
used-
at least one chance because otherwise I'm
This
not.
is a matter
willing to
from
pursue.
2013.
2013, that I know, my lord, because the case was.
If you know that,
Okay.
then why are you praying for time? 11
My lord,
years.
the specification is, my lord.
We have heard this matter,
specification-
madam, we could
The
have dismissed,
specification, my lord.
we could have disposed this
specification
on the
of
last
floor mill.
date. We could-
Specification of floor mill, lateral body was not there. So, my lord, there is some mistake, my lord. Otherwise, I have to.
4/1/2024, we are about to dispose of the matter. We gave you a chance. There
You
are
could not
professor
come, my
materials to come to a finding that it's a rural floor.
Then, my lord, I may be allowed to join with a liberty to
Then-
file. Otherwise, you will, my lord, incur heavy loss, my lord. Elizabeth
Okay,
certificate.
we'll give you liberty. 13 matter, we're not going to. Heard MS and Sekia, learned counsel for the petitioner. Also heard Sri A. Kolita, learned standing counsel, Industries and Commerce Department. It first, no? A
Last.
paragraph. A
Any
paragraph.
date of my lord, 22nd, 23rd.
No,
22nd
today
or
we
29th.
are dismissing on a trial.
But then I would have, my lord, because the person requests me, my lord, the petitioner, to take at least 1 day after Bihu so that he can come.
See, if there can, you
Preliminary
cannot improve,
instruction was not sufficient.
improve a case after 10 years. We'll decide on the basis
They
of the
did not
documents.
inspect, my lord, in pursuance of the court order, my lord, they did not inspect the industry, my lord. Without it.
We'll give you liberty to file afresh if you can show that it's a it's a floor mill, not a roller floor mill.
Yes,
1 and 2 paragraph, huh? Para. 3, paragraph 13 between ABJ, yeah? Para. When this matter was taken up on the last occasion, comma. Last occasion, that is 4/1/2024, comma, on the prayer of the learned counsel for the petitioner, comma, time was granted to obtain instructions.
no,
On
if I'm withdrawing it, then, my lord, all this not necessary to mention. Liberty.
We'll not say anything on marriage, don't worry. Something you have to write.
No, the only, my lord, that due to some difficulty, my lord, technical difficulty, withdrawing the. My lord, liberty.
That we'd like to put our own words. You will not dictate the order.
No, I'll not dictate.
Sorry, this
Don't
submission
worry.
we are not going to accept. Don't expect this submission to be accepted. Sorry. When the matter was taken up on the last occasion, 4/1/2024, comma, on the prayer of the learned counsel for the petitioner, time was granted to enable her to obtain instructions on this aspect. Full stop para. Ms. Sekia, the learned counsel has, however, submitted that concrete instructions in this regard have not been furnished to her.
Yes.
She, full stop. She accordingly submits that she may be allowed to withdraw this writ petition with, however, with a liberty to file afresh
There's
if
some technical.
if there are any materials to show, to substantiate the plea that the flour mill in question is not a roller flour mill, but an ordinary flour mill. Full stop para. Sri Kolita, the learned standing counsel, does not raise any objection to the aforesaid prayer, does not raise any objection in principle on the aforesaid prayer. Full stop para. Writ petition accordingly stands dismissed on withdrawal with liberty, with however with liberty as prayed for. Yes.
Obliged.
Item 3.
Wait, please, my lord. My lord, in this matter, Mr. D.K. Mr. Learned Senior Counsel was engaged.
Just a minute, just a minute. This will go before somebody else. Rituraj, Hitu Rajan. Please before any other bench without me.
Right.
Item 4.
Please, your lordship. My lordship, induced by the industrial policy of 2008, the petitioner carried out expansion of its unit, and thereafter it applied for the eligibility certificate for the various.
Which is the policy in,
Lordship,
which is the policy in question 2008 policy?
2008 one. Lordship, when we applied, and thereafter we applied for eligibility certificate for the various incentives. Lordship, the first incentive was issued, eligibility certificate was issued on 12/7/2016. Then it's at page 15, annexure A.
Date?
Annexure A, Lordship,
Date.
page 15.
No, date
Page, it is 12/7/2010.
12/7.
2010.
Eligibility certificate.
Yes, the first eligibility certificate.
Okay.
And Lordship will find in the eligibility certificate at paragraph page 15, the electrical incentive for electrical installation,
Hmm.
the additional incentive investment was taken as 63,052 and 117. That lakhs, Lord. 63 lakh 52,117
At page 15.
at page 15 at
Yes.
G.
Yes.
And then Lordship, we were given a subsidy of for total expenditure was calculated at 452.16. That's the page 16.
Yes.
And but Lordship, however, we were categorized as medium scale industry, despite the fact that our investment was less than 5 crores. And any investment under 5 crores, as per the MSME Act, which is adopted by the government, is
You
categorized.
said the total incentive, total remission was 452.16 lakh.
1 lakh. So it was below 5 crore. So we should have been categorized as a small scale industry, and we were categorized as a medium industry. The difference is that in case of a small scale industry, the tax exemption is 100%, and in case of medium scale industry, it is 90%. So we wrote to them several letters we wrote, and they did not act on it. Thereafter, we filed a writ petition before this honorable court.
Just a minute. You came before this court.
I came before this
Page?
court. The order passed by this court is at Annexure C, page 90, in page 19.
19.
19. So the relevant portion is at page 20. In view of the above stand of the concerned respondents and agreed by the rival counsel, the case is disposed of by directing the respondents to complete the rectification exercise expeditiously, preferably within 3 months from the date of receipt of intimation of this order. The petitioner will do the needful in the matter. So this is what the order was passed right now.
Yes.
Thereafter, Lordship, they took up the exercise, and then they issued us a eligibility certificate, which is at Annexure D.
As small scale. As small scale.
A small scale. But what they have done, Lordship, the electrical installation, Lordship will find at page 22, G, electrical installation, which they gave the additional investment of 63 lakh in the earlier certificate.
22 page.
Page 20,
I mean, serial number?
G.
Page 20, where G is there? Is there 1, 2, 3, 5, 6, 7?
And then 4G, Lordship. 4G. Fixed capital investment value in rupees.
Page 22.
Page 22, Lordship. Annexure D.
There is no 4.
4, Lordship, 4 will go down. at G.
It's page 23. 23.
Page 24.
It's 23.
20
Annexure D starts at page 23. Doesn't matter.
Yes, Doctor, I think that's something mistaken. It's at G,
G.
electrical installation loss.
4G, 4G.
4G.
This is the certificate dated 23rd of June.
Yes. 2014, after
Correct.
the order of this honorable court. Electrical additional investment is shown as 0, which was shown as 63 and odd lakhs in the previous certificate. That has been taken up. And our total investment was worked out in the next page at 4,388,787. 4 crores 38 lakhs. 87 only. And they classified us as a small scale industry. And what they did, they changed the total investment, got it down by deleting the installation, electrical installation. So my contention here is got here. We have written to them that they can't do that because electrical installation is a fixed capital investment.
Now, was it an additional investment?
Yes, Doctor.
See, they have come to a finding at G that prior to the substantial expansion,
Yes.
they have come to a figure of your investment so far as electrical installation is concerned,
Yes.
like the others. But so far as additional investment made for substantial expansion is concerned, which really concerns the policy, there we find that in the other heads, they have found figures.
Yes.
In number 1, number 2, 3, there is no figure. 4, there was no neither earlier nor before. 5G, there is no additional investment.
And they show this as 0, but in the earlier policy, Doctor will find they've calculated it at 63 lakhs 52,000.
Page 15, you had said.
Page 50.
15.
Yes, that they have deleted.
Okay. Oh, that wasn't the investment.
That they deleted. They classified as a small scale industry, but they deleted that and they got a total investment down. Earlier, it was Lordship 4 crores 52 lakhs. Now they got it down to 4 crores 38 lakhs. They reduced that amount.
Okay, just a minute.
So,
Building, development. 463 This is the 54. Admission 52. Parallel. 263 years. 94. Yes, that is your case.
that is my case.
Yes.
And my
We will just come back to Madam. Mr. Kulte.
No,
Just compare 15 and
yes,
23.
that has been taken.
Now,
is-
except these, all are telling.
Correct.
all of that.
It is not a case that you had made a re-verification kind of a thing.
No.
Then the amounts in other heads have also
No,
differed.
Lordship, what has happened is that, I mean, this eligibility certificate was basically issued for tax exemption purpose. So now in the policy of 2018, a policy
2008.
2008, policy of 2008, that I mean, fixed capital investment, that has been defined. So that has been defined as, Lordship, I have filed an affidavit. Lordship will find that small affidavit I have filed. So there in 7.
Are you contending on merit that it is not an error, but it
No,
is
yeah.
done
No,
intentionally
no,
because
what has happened, Lordship, earlier in 2010, when the eligibility certificate was issued, then there was an error. That is admittedly there was an error committed because they have accounted that electrical installation part, which should not have been actually accounted. So when later on, when in 2014, when the certificate was supposed to be given, then it was scrutinized by the panel. Then tax department actually initially they pointed out that this is not in the definition. In the definition part, only the fixed assets that has been defined. So now that part is not under the policy. Now what has happened is that
are you trying to contend that electrical installation
yes.
will not come under fixed capital investment?
Correct. So 7.1, there is a definition. I'll just read out the definition here. Definition says.
That means it is not a mechanical error. It's an conscious decision to exclude.
Consciously.
Because as per you, this investment for expanding electricity
Lord,
connections or electricity installation
Lord,
will not come under the definition of fixed capital investment.
Lordship.
And therefore, that part of the incentive has been removed.
Removed, taken here, because there was a mistake committed. It was later on found out there was a
Where have you
mistake.
stated in your affidavit?
Lordship,
Where is this standard in your affidavit?
Lordship, I have filed an affidavit, so I have stated here.
Okay, then I will let her complete.
Lord.
Just want to have a clarification.
Lordship,
Yes,
I
madam.
Lordship, fixed capital.
You have understood what it will be his.
Yes, I've understood, Lordship.
One more thing, Lordship, I'll just clarify, because what has happened is that there was an operational guidelines of, because in the operational guidelines, in fact, Lordship, the electrical installation was included. So they thought that because though the policy doesn't allow, but like the operational guidelines, that electrical installation was there.
Okay, we'll come back to yes,
Correct.
let her
Now,
complete.
now, Lordship,
Let her complete. Let her
yes.
complete.
I'll explain.
Yes.
Lordship, industrial policy, which was issued at 7.1 has clearly said what is a capital investment. Now 7.1
Page.
last page. Oh, that's on detail. I'll just give a copy though.
Is it not a part of the written?
No, I have not. It's a huge document. I'll just give yes, 7.5 and give the 12 also. Operational guidelines and RO. Chapter 12.
You are interns on the back. Take a seat. Don't stand like that. Find a seat. If there are seats vacant, you can sit. Otherwise, you don't sit. Yes.
Lordship 7.1 talks about what is the fixed capital investment.
Right.
Fixed capital investment means, and
This is a part of what?
it's a part of the industrial policy.
Of 2008.
2008. It means it includes investments in plant machinery or additional investment in plant machinery for expansion of units and building connected directly with the manufacturing process. This is what it has been defined. Now, Dr. I have just given one more chapter of the manual of the industrial policy. That is chapter 12. Dr. Will look at chapter 12.
Which page?
Chapter 12, the last 12.6.
Page.
Lordship, this I've given a separate chapter.
Okay.
It's a lot.
Chapter 12. Yes, chapter 12. Correct.
Now, Lordship, we find it 12.6, a set of guidelines, including application forms and procedures for getting various incentives will be issued separately. And at 12.4, it says, the decision of the Industries and Commerce Department, Government of Assam, regarding interpretation under this policy shall be final and binding. These are the two things it said. Then pursuant thereto, they have issued the operational guidelines.
Okay.
Lordship will find that the introduction, these guidelines have been framed under the provisions of Chapter 12.6 of the Industrial and Investment Policy of the Government of Assam, 2008, with the objective of specifying the procedure to be observed for obtaining eligibility certificate for availing incentives, providing for the Industrial and Investment Policy Assam 2008. It will be effective from 1/10/2008 and will remain valid for a period of 5 years or till such time as the government may consider. Then Dr.
This is under 12.6, which you have just read.
Yes, I have,
Chapter 12.
Yes.
Okay.
so then this has been issued and Dr. will come to the next page, that is R2, fixed capital investment. Fixed capital investment means and includes.
Where are you reading?
At the
Yes.
next page, Lordship.
Next page, correct.
Next. Fixed capital investment means it means an include investment in plant and machinery, public equipment, or additional investment in plants and machinery equipment for units undertaking substantial expansion or second industry and building and civil construction. This is there. Then Lordship will come to the next page. Investment in plant and machinery is defined here. Investment in plant and machinery of big equipment means and includes
You're at R3.
R3, the last
Yes.
one. Investment in plant and machinery of big
Yes.
equipment means and includes original prices of the main machineries, equipment, to accessories like dies, molds, tools, jigs, fixtures, etc., quality control, R&D, pollution control, firefighting equipment, machinery equipment installation, erection and commission, including charges paid for technical know-how for erection, bank charges, service charges paid to NSIC, etc., for hire purchase of machinery equipment, accessories, components, etc., for installation, including dedication of transformer.
Dedicated.
Yes, dedicated transformer, gas products, plant power generation sets, etc., and storage space, etc., etc. They have included all these. Now, my contention is that drawal of power line is not, it doesn't come under this one. They have excluded drawal of power. So my contention is that electrical installation is very much included in that, and knowing that they have included these in the first policy. Now, in the first policy which we issued to us in 2010.
No, we read again, number 6.
Yes, Lord.
Yeah, number 6, equipments.
Yes.
That page R3.
Yes.
This has to be read in the context of equipments.
Yes.
Equipments, accessories, components, etc.
Yes.
For utility installations, including dedicated transformer, gas producer plant,
Yes.
power generating set, etc.
Yes.
It is not for the line per se.
So line is not there. When the 63 lakhs was calculated, Lordship, the policy was very clear, except for drawal of line. Lordship will look at Annexure A. Annexure A makes it very clear.
Yeah, page 14.
Page 14.
Yes.
This is it. Electrical incident other than drawal of power line. So a power line has been excluded when this was calculated.
Okay.
Now they agree. This electrical is, but they want to, what their contention here is that this operational guidelines has no value. It needn't be implemented. Or they'll implement where they want to. That is what they say. That is their contention, is that the industrial policy will override the operational guidelines. Now, these guidelines are nothing but clarification by, and it has been issued under 12.6. So it forms a part of the policy, because in the policy it's clearly written that it and lot of people look at the minutes of the standing state level committee, paragraph 10, page 10 of the affidavit.
Submissions.
Now, Lordship.
Just a minute. 14. 1. 1. Okay, yes, please.
Lordship will look at the minute that
Page?
Page 11 of the affidavit. the member secretary informed the committee that in the industrial policy of 2008, at para 7.1 under VAT exemption, fixed capital investment is defined as this. As per the operation
This was
guidelines,
filed when?
Lordship,
Filed on 19 to 15/5.
this was passed on in 2010, I
And 15/5, 2019. No affidavit.
in the affidavit. Yes,
15/5, 2019. Yes, in the affidavit, which page are you trying to?
I am this was of the
Page?
page 10.
Page.
This
10.
is of the meeting held on 31/5/2010. 31/5/2010.
Okay.
Then they say the member secretary informed the committee that the industrial policy of Assam at para 7.1 under VAT exemption, fixed capital investment is defined as this. As per the operational guidelines of the industry's invest policy of Assam, the investment in plant machinery equipment means and includes the original price. That's the definition they have quoted. The Commissioner of Taxes, Lordship, by his letter number this, dated 2/36/5/2010, in connection with this view of eligibility of Messrs. This, indicated that costs towards drawal of power line and electrical installation may not be included in plant and machinery as per industrial policy. That is the opinion of the Commissioner of Taxes. However, under the industrial policy, there is 25% subsidy for drawal of power line, indicating that investment of drawal of power line under the eligible certificate is essential so that the unit would avail the incentive. The member secretary requested the committee to discuss the matter and take a decision on the eligibility components for computing the fixed capital investment for grant of eligibility under the policy. After detailed discussion, the committee decided that the operation guideline cannot supersede a policy. As such, as indicated, the industrial policy is in the investment in plant and machinery or additional investment plant and machinery for expansion of units and buildings connected directly with manufacturing process will only be treated as eligible component for computing fixed capital investment for VAT exemption. The committee also decided that the definition of plant and machinery indicated in the operational guideline is modified and necessary corrective is to be issued by the government. So by this meeting, they seek to modify the operation guideline. The committee also further decided that though the investment for drawal of power line will not be taken to account for computation of VAT exemption, the electrical investment in drawal of power line will be indicated in the eligibility certificate so that they could avail 25% subsidy for drawal of power line. So this is what was the decision. They said this doesn't matter, we don't have to look into it. Whereas in chapter 12, they say for interpretation only the director will know. Now, Lordship, this meeting was held on
When 31/5.
31/5/2010.
10.
Thereafter, Lordship, probably it was reconsidered because my first eligibility certificate was issued on 12/7/2010. After that meeting, and I was given electrical installation was taken into account 63,000, 63 lakhs. That was included. After this meeting,
Page 14, you are saying.
yes, 14 is 12/7/2010. They had included this. So they now can't take the help of this minute and say, no, this is the decision, that was a mistake. And now in 2014, at the behest of the Commissioner of Sales Tax, this is what has been done.
Okay.
It's clear from the minutes, Lordship. And Lordship, and this operational guidelines was implemented, is a part of this because this policy clearly says, because the nitty-gritties of the policy will not be in the industrial policy, they'll have to have a guideline. Now, they cannot say that these guidelines are not binding. The number of decisions of the Supreme Court, where they say they have to abide by the guidelines. If the government has a set of guidelines, they must abide by the set of guidelines. I may not be eligible. Just these two documents before your Lordship. I just 2 copies of that. Lordship, 2009-13 SCC, page 578 at para 9, para 9, Lordship.
Name?
Name, Lordship. Lord Saran Singh Chand versus Punjab Electricity Board. At paragraph 9, the guidelines issued by the state is binding on it, a clear status. And again, Lordship,
Just a minute. Paragraph 9, you said.
yes.
What was the context?
In context of a retirement of a person. And this Lordship, this
Just
is
a-
another one in regard to transfer of land by DDA. One more I'm placing, 2003-7 SCC, page 301.
Two thousand three. 2003. 7 SCC. 301. Paragraph?
The second one, Lordship,
Yes, DD,
paragraph 10.
DDA.
DDA. The rationale behind formulation of policies and guidelines issued by DDA is to curb illegal transactions in favor of persons not of blood relation of the allotee. Then Lordship will look at the last paragraph. As already stated, the DDA is a feature of the statute, and any policy decisions or guidelines formulated by such authority will have to be binding, will have a binding effect on the parties in absence of any rules to the contrary. So this clearly makes it, now you cannot come and say that these guidelines are not binding. And all the forms, everything is as per the policy law, as per the circular law, as per the operational guidelines. Everything which they do, we follow the operational guide. Only for the purpose of investment, they say, then it's not, it doesn't override. That's all. What? Hmm?
Yes, Mr. Kunti.
Perceive that my affidavit or that has been already pointed out, that stand we have taken. So the issue is Lordship, basically coming down to a very small issue, that whether the guidelines supersede the policy. I mean, guidelines has been framed to implement the policy. So whatever is there in the policy, that how it is to be implemented, who will implement
Now
it.
first the question will arise, who has framed the guidelines?
The guidelines have been framed by the department, by the department, and the policy has been basically done by the legislature and with the cabinet. So policy, under the policy guidelines have been framed. The guidelines is basically framed by the delegated, and policy is the substantive. I mean, now the issue is on only one. Issue revolves around only one thing: whether the guidelines can supplement certain things or supplant certain things in the policy.
That is the question which you like to put. In fact, you wanted to put.
Correct.
First, the guidelines are not issued without any authority of law.
It's under.
There is a clause
Correct.
which in fact directs framing of guidelines to make the policy workable and executable.
Correct.
You have framed the guidelines
Lots,
and it's framed by the department.
lots.
The validity or the efficacy of the guidelines is not questioned by anybody. It is for a department to change the guidelines.
Sure.
Department has not done so. Now, guidelines is only to implement or execute the policy and is only to supplement. It cannot, it's not a supplement
Correct.
kind of a thing. It's not altered any part of the policy.
Correct. The which is not there in the policy, whether the guideline can bring it.
Yes, exactly.
Correct.
Now,
So that is the issue.
that is the issue. Now, whether if you so for just for the sake of arguments, you are trying to project that the policy is the substantive law,
Lot.
and by guidelines you cannot change
it.
something
You
or
cannot alter it.
you cannot already do something which is not permissible by the policy.
Which is not there in
Now
the.
that guidelines, if you take a similar analogy, the guidelines is by the department.
Sure.
Is a committee empowered to say the guidelines are not applicable?
No, guidelines are applicable. I mean, guidelines are applicable to certain extent.
No, so far as this part is concerned,
Yes.
the first, Madam has also argued that even the first eligibility certificate was after the policy decision. But we may not go into that. Perhaps
That's a
you
technical,
must have
yeah,
overlooked that.
That may
Overlooked
have
that.
been-
But
may have been
whether the committee will have the competence to say that the guidelines are not applicable.
No, Lordship. No, Lordship, guidelines, the committee hasn't said guidelines is not applicable.
No, committee has in fact said that.
I'll just read out like what committee has said.
Come to page 39 of
Yes.
your page 11 of your.
Yes,
affidavit.
what committee has decided ultimately.
No, that is, has said that this is
That-
directly in conflict,
No,
cannot
no,
supersede the
Lordship,
policy.
yeah, I'll just read out Lordship, what committee has decided,
Yes,
page 11.
yes. The
No,
line,
Lordship,
paragraph starting after
I'll
detailed.
I'll come to the relevant paragraph, that
Hmm.
is 1 to 3rd from the bottom.
Yes,
After detailed discussion,
Yes.
Lordship, after detailed discussion, the committee decided that operational guidelines cannot supersede a policy. So that's the stand they have taken because a policy, something else has been said.
does the committee have the competence to say, make such
This is Lordship, it's a high powered committee of SLC.
high-powered committee will
This
be
is-
above the department?
No, this is the department, this is the recommendation to the department.
No, but you have acted on this.
That this is ultimately because ultimately it's a recommendation to the department to change the guidelines. And department has, department has subsequently in 2014 operational guidelines, they have changed it.
Now this impugned decision
Sir.
is based on this minutes, isn't it?
Yeah, it's
Now, is
Sir,
there
the-
any, is there any stand by the department that yes, we have changed the guidelines before, while considering this?
not that to that effect, nothing has been.
See, there are two certificates here. One at page 15.
One is that, yes, sir.
One is at page, after the High Court's order was there,
Correct, correct,
rectification,
yes,
that while doing so, you have deleted one part. You said that it may not come under the fixed capital.
Correct.
Now, guideline says that the stringing part obviously is outside. For that, you have got other incentives. But there are other items, accessories connected to utility. Utility is a very broad subject, and no one can argue that electricity is not an utility. It's 100% utility. Now, for that, that is on the merits, but we are on the competence of the committee.
Lots of state level committee is an empowered committee to decide which will be included in the subsidy, which will not be included in the subsidy.
You are
taking
correct.
into account-
You are absolutely correct. You are absolutely correct
Correct.
on that. They can they can come to a conclusion, decide whether a particular unit within the framework of the policy and the guidelines is
falls
eligible.
under that.
Now, they have gone to some a step further, saying that the guidelines seems to have superseded the policy. Whether that part is available to the committee.
The Lordship, in fact, Lordship, a similar case happened. The Supreme Court, it has gone to the Supreme Court. And
Uh,
Supreme- now,
Case of Assam.
it's a case from Odisha.
Okay,
But like on the face of this case, like, I mean, this case in fact it specifically states that a guideline, this is also under industrial policy, okay? That
okay.
the guidelines which have been framed under a policy cannot supersede or like it cannot alter the policy. That's specifically it has been stated there. So now on the face of this law, which has been made by the Supreme Court, whether this committee, SLC can allow it. That is the-
Let us see that.
that's Lordship, I mean, that is 2007-8 SCC 118.
2008
8 SCC 118.
SCC 189 name.
State of Odisha and others versus Tata Sponge Iron Limited. Tata Sponge Iron Limited.
Paragraph.
Paragraphs of multiple paragraphs, Lordship, 4, 5, 6, 4 to 10, 4 to 12,
No, the only the relevant paragraphs.
13, paragraph 13, Lordship, that 13, Lordship, let's see. Paragraph 13.
13.
So what is the factual part, Lordship, has to take into account. Factual part, Lordship, has to take into account. So Lordship, I will read out from paragraph 4. So Lordship, in this case, what has happened? There was a policy. Under that policy, there was no time limit as such. I mean, there was no time limit of availing the benefits under the policy. Now, operational guideline was brought in, and the operational guideline, what operational guideline did, they brought in a time limit. Then, in that case, Supreme Court stated that if when the policy did not give any, did not prescribe any time limit, the operational guideline cannot take in time. So you can alter the provision of the policy. That was the basic principle that has been laid down here. So I'll just read out Lordship, from paragraph 4.
4.
The factual part Lordship needs to
Yes.
take into account. The respondent herein, which is a large industrial unit, had set up a sponge iron factory at Vilaipara, Jora, in the district of Keonjhar, Odisha. Indisputably, it is classified as a large-scale industry in terms of industrial policy resolution in 1980, adopted by the state. In or about 1989, IPR was adopted for existing industries classified under IPR 1980, wherein benefits for exemption from payment of sales tax on finished products were to be granted subject to terms and conditions laid down therein, including repayment of loan availed under IPR 1980. Before the benefits of the said IPR could be obtained by the respondent, the government of Odisha announced IPR 1992 in terms whereof the existing industrial units could obtain exemption or deferment of sales tax on finished products, and the capital investment subsidy provided it had undergone an expansion, modernization, and diversification of its units. For our purpose, we may only notice paras 7.4 and 7.5 of IPR 1992, which are in the following terms: exemption, deferment of sales tax on raw materials, spare parts, and finished products of small, medium, large-scale, and pioneer industrial units. New small, medium, and large-scale industrial units, including pioneer units, will be eligible for exemption of sales tax of raw materials, spare parts, and finished products for a period of 5 years, subject to a ceiling of 100% of fixed capital investment if the unit is located in Zone A, 75% if the located in Zone B, and 60% if located in Zone C. New, medium, and large industrial units may also opt to defer payment of sales tax on their finished products for a period of 5 years, subject to maximum 100% of fixed capital investment if the unit is located at Zone A, 75% if they're located in Zone B, and 60% if located in Zone C from the date of commercial production. Deferred amounts in respect of each year will be repaid in full after the expiry of the period of deferment annually. Period of exemption and deferment allowed for different zones shall be extended by 2 years for pioneer units. However, a defaulter of OSFC dues shall be eligible only after the clear of such dues. 7.5 exemption, modernization, diversification. This is relevant. The incentive by way of exemption or deferment of sales tax on finished products shall be available for expansion, modernization, diversification of units taken up after effective date, subject to a limit of 60% of the additional capital investment in the plant and machinery only in Zone C, 75% in Zone B, and 100% in Zone A, provided that such expansion, modernization, diversification has been undertaken on the basis of separate project report duly appraised by the financial institutions, and provided further that subject to provisions of the sales tax and sales tax, the benefit of exemption deferment shall not have the effect of reducing the sales tax paid by the unit prior to commencement of the expansion, modernization, diversification program. In other words, the benefits shall be applicable to incremental sales. The respondent contended that in view of paragraph 7.5 of IPR 1992, it was entitled to the benefit of deferment of payment of sales tax on finished products in respect of incremental sale over and above the immediate preceding year, as it existed prior to expansion of the industrial unit up to a limit of rupees 49.545 crores, being 75% of the fixed capital investment in the plant and machinery. It was further claimed to be entitled to capital investment subsidy. As the said benefits were denied to the respondent, it filed a writ petition before the High Court, Odisha, Cuttack, which was marked so and so. By reason of impugned judgment, a division bench of the Odisha High Court allowed the said writ petition, directing opposite.
We have read the judgment.
Paragraph 8, Lord.
We have read the judgment.
Paragraph 13, Lordship has stated.
See, the challenge was by the SSC.
Lordship.
The case, in this case,
Correct, Lordship.
challenge was by the SSC by saying that an incentive which we have given by the main policy,
It
we
was
are
not.
trying to curtail by a guideline.
Correct.
And therefore, the Honorable Supreme Court has said that you cannot curtail something by a delegated legislation.
Absolutely.
Now, that was this particular challenge, specific challenge. Now, here the guidelines are not challenged.
No, that is perfectly fine. But the ratio, Lordship, the ratio is like whether the guidelines can supersede the policy or
No,
not.
that has not even arisen for consideration in this case.
No, that has come, Lordship.
No, in our case.
No, in our case, Lordship, our case, the same issue, Lordship.
No,
I mean, the stand taken by the.
The reverse is not the correct. You have to make a specific challenge. Somebody has to come and say that either you could have revoked the guidelines.
No, that in subsequent guidelines.
We have the power as a
Lordship,
committee. You have the
Lordship,
power to revoke
Lordship,
the guidelines.
2014 guidelines I have. The 2014 guideline that has been rectified.
Now,
2014
after
guideline.
14, if we are considering for the period in
Yeah,
which
correct,
the
Lordship.
law was existing. Now, as on today, the law may be different.
Yeah, that is correct, Lordship. But now.
14, after 14, if the investment was made after 14, they may not be able to have the incentives.
Now, Lordship, Lordship, this eligibility certificate was issued on 11/7/2014.
Yes.
And this operational guidelines, it has come in the month of December 2000, but in the same year. So rectification was done after Lordship. That decision has been taken. That this policy, I mean, that was a decision taken by the SLC, the high powered committee, which is.
No, the competence of the department is one part. Competence of a committee, maybe a high-powered committee is another part.
So
High-powered committee will not have the
no,
power of legislation or
Lordship is
legislation.
absolutely correct. Lordship is absolutely correct. We cannot do, the SLC could not have done the correction in the
And Mr.
operational guideline.
Kolita, we could have understood if you were finding some fault with the investment kind that they have not actually done. You have not gone on the facts. You have gone on the guidelines itself. That for this transformer, this, you are not entitled because it amounts that guidelines is transgressing on the policy. But whether you are competent to make such a statement, in the policy there is no policy when the guidelines in fact include such incentives.
So, Lordship, that is what I was reading.
And this same Odisha case, you have seen paragraph, the penultimate paragraph.
Yes, Lordship.
At paragraph, the second last paragraph.
Yes, Lord.
It is furthermore well settled principle that the law of that an exemption notification must be liberally construed.
No, that is correct, Lord. But here
That is the general policy.
ultimately, Lordship, the ratio is that like that policy cannot be superseded by operational guidelines. Now, in this case, the same thing happened. And on the face of this law, which is settled law, whether like SLC could have allowed this. After the that
No,
after
was
the fact of-
was there an occasion for the SLC
Lord.
to go into this matter when the guidelines were not the subject matter of challenge?
that has been pointed out, Lordship. There was a mistake committed by the
Who pointed out?
the member of tax department. When the tax exemption issue came, because it will go to the tax department, and a member of the tax department is also a member of the SLC. So he has communicated it. Now
He could have gone to the legislature, revoked the guidelines.
no, Lordship, that
As
I
of
mean,
existing guidelines, how
they
can you
have
say
not-
that guidelines are not applicable?
they have not revoked the
Sorry.
guidelines. They have
Difficult.
only pointed out.
Difficult for us.
They have only pointed
Had it been
out.
something else, some fraud committed or some undue advantage tried to be taken on this ground? is very
In my humble
difficult.
submission, Lordship, whether the SLC could have allowed this after the mistake was found out, whether they could have allowed
No,
this.
it's not a mistake. It's not a mistake. It's a conscious decision you are saying.
No, conscious, the earlier one was a
No,
mistake.
leave it, said the earlier thing. Here, suppose you are examining fresh.
Sir.
You are denying them, saying that no, even though the guidelines gives, it seems that it is against the policy, so you are not giving.
Correct.
Can you do so?
See, because of the.
Can you do so?
Because that is the law. Because that is the law, Lordship. And we have given a eligibility certificate. It's not that we have not given a eligibility certificate. We have only taken out which is not allowed by law. But that is a settled law, Lordship, on the
Yes.
face of it.
But
Because
is
of
there-
the-
is-
because the-
Mr.
Lordship-
Kolita, we are again asking you,
Lord-
is there a judicial pronouncement that this guidelines is against the policy? From where do you get the power? A committee?
The
Are you the
committee,
legislature?
committee is only saying that this cannot be. allowed.
Committee becomes the, is all,
The Lordship committee will scrutinize it whether a particular.
committee will be, has to act within the four corners of law. Law which was prevailing at that point of time, they have to act. But how does the committee get the power? Just tell us.
No, committee has the power. No, committee was framed under this policy only.
No, committee
Committee has
take
been-
a call
No,
that
Lordship,
these guidelines are against the policy.
that Lordship, they have only pointed out the government will decide.
Yes,
That is
anything
Lordship is
else?
absolutely correct in
Mr.
that.
Gokul.
No, Lordship is absolutely correct in that. But that has to be decided by the government, and government has decided it.
So far as the observations of the committee is concerned, as a matter of principle, we do not have any difficulty. A guideline cannot supersede a policy. But who will question this? A committee which has been constituted by the policy has to follow the guidelines. You can make some observation, the guidelines does not seem to be in conformity. But can you say that we are not going to follow the guidelines?
So that is,
Do
the
you have that
language was-
competence?
language.
Yes,
was
Mr.
not-
Gogoi, you're
The
for.
long language was Lordship.
Yes, anything?
Here, so far as the policy concerned, has already gone through the definition of substantial. There, my lord, this electrification part is not there. It only speaks about, my lord. big
No,
increase in the value of
we had in fact applied our mind in that. If it was not that, what it says is utility.
Right.
Have you seen that term utility?
in the, my lord, operational cut.
Huh? No, that page. Where is that page? Is it a part of the repetition? No.
Big capital investment means can include investment in plant and machinery or additional investment in plant and machinery for expansion units and buildings connected directly with manufacturing process. 7.1. And this,
No, R3. Where is R3? The policy,
No, that's the
operational guidelines.
so Lordship, may I indicate, madam?
Yes.
Before that, I will come to that. Now, my lord, in,
Where are you, what are you reading? Chapter 3,
my lord,
chapter
I'm-
12.
no, my lord, chapter 4 of
Where
the
is it?
industrial policy.
Where is it? Is it part of the
So it's not
petition?
part of the.
I gave the date. I gave a copy.
Okay, okay, yes,
4.5.
7 point?
But it's 4.5.
4.5.3. Okay, we have.
But this is the main
Substantial
policy.
expansion, yes, you're right.
Substantial expansion means
Mm.
increase in the value of fixed capital investment in plant and machinery of an existing unit by at least 25%, as well as increase of employment of at least 10% and at least 25% increase in the production compared to average annual production of various of previous period.
Mm.
Prior to going for expansion, the unit
Mm.
should be operating at
Mm.
least at a minimum of 80% capacity during the period of
Mm.
three previous years and prior intimation to the concerned implementing agency.
Mm.
Now, my lord, regarding tax exemption, my lord, it is chapter 7.
Yes. Tax incentives.
Yes. Lordship has already gone through the, my lord, just below the chart, my lord.
Yes,
It says, my lord, the same definition, my lord, it has been mentioned.
correct.
Now, the last para of the first part, that is
Mm.
7.1, the
Mm.
finance department,
Yes.
government of Assam shall be the implementing agency for tax incentive.
Yes,
The finance department will bring out a separate notification in this.
yes.
Now, my lord, Lordship may kindly turn to the chapter, my lord, 11. It's there, my lord. Chapter 11 says regarding the
Chapter 11
procedural
is not
implement.
there. Can you give that relevant page?
12.
12 we have.
My lord, just I will read out and I will participate.
Okay, okay. What is that?
Lordship may kindly point out my chapter 11, procedural simplification.
Hmm.
No, my lord, I will read only chapter 12. Yes, I'm sorry. Implementation and monitoring, chapter 12.
Hmm.
12.1, my lord.
Yes.
All incentives under this policy can be claimed only after obtaining eligibility certificate from the prescribed authorities as below.
Hmm.
12.2, committees for implementation of incentives under the policy. The state government will notify the following committees for scrutiny of the applications and to approve the deserving cases for issuance of eligibility certificate for the entire fiscal and tax incentive under this industrial policy. The committee shall meet as and when necessary and at least once in every quarter. The chairman may invite experts to join.
Okay.
So these are the committees, my lord. Here D will be applicable to the state level committees for
Yeah.
small scale undertaking. So, my lord, while considering the applications for eligibility certificate, they will have to follow the policy by any means. And 12.6 speaks about, my lord, this regarding that, my lord, operational guidelines. A set of guidelines, including application forms and procedures for getting various incentives, will be issued separately.
Hmm.
So, under this power, my lord, 12.6, that operational guideline has been.
This is issued by whom? Operation guidelines?
By the industry. Now, my lord, as per this, my lord, the clause 7.1, now, my lord, the tax exemption scheme has been, my lord, has been formulated, my lord. It was published on 3rd of November 2009.
Which one? What?
The Assam Industries Tax Exemption Scheme 2009. Under the power, by exercising the power under, my lord,
Where do you
7.1.
get? Where do you get?
It-
Assam?
Assam Industries Tax Exemption Scheme 2009.
No, Nigama.
My lord, a lot may have a.
We may have that book. Kasam ki book bahir
So, in volume 2, probably.
Assam? Assam? Or I can't remember.
My submission is, my lord, so far as this particular
scheme of the finance taxation department is concerned, which has been, my lord, formulated pursuant to the power, my lord, granted by clause 7.1 of the policy. The definition of substantial expansion is same as, my lord, in the policy. So in order to, my lord, have the benefit of tax exemption, my lord, we will be following this particular policy. Just I want to say. Because, my lord, after getting the eligibility certificate, that, my lord, I will have point of.
You are reading what? 2009. What are you trying to,
My lord, that definition of substantial expansion, category P,
this is Assam Industries Tax Exemption Scheme.
yes.
Same
Under, my lord,
policy, same
clause
policy,
7.1, yes,
same policy.
same policy. But, my lord, this is the separate policy regarding tax exemption as per the power, my lord, conferred by clause 7.1 of the industrial policy of 2008.
Exemption scheme 2009. Okay. Same definition.
Definition is same.
Yes.
But what I'm saying is, my lord, after getting the eligibility certificate, a particular, my lord, industry, in order to get the tax benefit, my lord, you'll have to apply for an entitlement certificate. Then again, my lord, it will be examined.
Hmm. Eligibility certificate has to be followed by an entitlement
Yeah, that
certificate.
is there in the
Okay.
For that, my lord, again, it will be examined. Now, my lord, this part, my lord, since it is not there in the definition of the, my lord, our scheme, probably, my lord, so far as the tax exemption is concerned, for this, my lord, particular, he will not come under this particular scheme of the finance.
Is
This is
that,
my humble
is,
submission.
is
Because, my
that,
lord,
is that what is reflected in the
levying of
minute?
tax is the, my lord, rule.
Mr. Gogoi, you
Exemption
are
is
making
the
a
exception.
submission, but is it reflected in the minutes of meeting?
No, that part will come later.
No,
Moment, my lord,
later on, it's up to you. We are not even contemplating what will happen after.
tomorrow, if you go for the
eligibility.
entitlement certificate, because the petitioner is yet to receive the entitlement certificate.
It's up to you. We cannot contemplate what's going to happen tomorrow.
Yes.
You still have to have the scope to examine whether after the eligibility certificate he is entitled to have the
For
entitlement
tax,
certificate.
yes.
Then you-
Eligibility, my lord, it will be applicable.
See,
for
we
the-
are only confined to examining the correctness, the lawfulness of the decision
My lord.
making process.
Because why I'm saying is, my lord, under this particular policy, they will get the benefits for
Right.
power supply, my lord, for transportation, including PWD also, they used to get some, my lord, benefit. So for tax, my lord, there is a separate, my lord, policy or scheme, my lord, pursuant to the policy. That, my lord, liberty may be given by that time. We will
That
examine.
we are not going to say anything. Why liberty? See, this is the second round of litigation. First round says that you rectify.
Rectified.
Why rectifying? You have done something which they are questioning.
It has been rectified as per their terms, but, my lord, only one part has been left out. That is the, my lord.
That is the subject matter of dispute. Okay.
Lordship, I still humbly submit that minutes of the meeting, it was only pointed out that it cannot be, probably it cannot be given. That is what.
Page 38. Page 38.
Yes. No, page 11 of that affidavit. So it was.
That is running page 38.
And
Your 31-5 meeting, you are saying 31-5.
Yes. So and only the thing is that it was recommended that it should be by horizontal, it should be modified. That was recommended. That. So on the face of my humble submission is that, Lordship, on the face of the statute law, whether SLC could have allowed that. That point, Lordship, may kind. That's it.
Let us see the operating part so far as
This minutes,
minutes, yes,
yes, Lordship, page 11.
11.
I'll just read out the whole thing, Lordship.
No,
How
no, no.
it is
Yes.
coming.
Hmm.
I'll just read out once more. The member secretary informed the committee that in the industrial policy Assam 2008 at para 7.1 under VAT exemption, fixed capital investment is defined as fixed capital investment means and includes investment in plant and machinery or additional investment in plant and machinery for expansion units and building connected directly with manufacturing process. So this is the definition, Your Lordship, in the policy.
Hmm.
As per the operational guidelines of the Industrial Investment Policy Assam 2008, investment in plant and machinery stroke equipment means and includes original price of equipments, accessories, components, etc. for utility installations, including dedicated transformer, gas producer plant, power generating set, etc. Commissioner of Taxes Assam by later that so and so 26/5/2010 in connection with their views on eligibility of measures NK Plastic, that's a different unit, indicated that the cost towards the drawal of power line and electrical installation may not perhaps be included in the plant and machinery as Industrial Policy 2008. However, as under Industrial Policy 2008, there is 25% subsidy in drawal of power line, indicating the investment in drawal of power line in the eligibility certificate is essential so that the units could avail incentive. So that is separate, Lordship. Drawal of power line, get 28% they will get. The member secretary requested the committee. The member secretary requested the committee to discuss the matter and take a decision on the eligible components of for computation of fixed capital investment for grant of eligibility.
NK is the petitioner. What is your name?
Ladistel.
I'm not.
NK was a different unit, Lordship. It was discussed that, decision was taken as far as the electrical installation in this meeting. So now fixed capital investment for grant of eligibility certificate under the policy. After detailed discussion, the committee decided that operational guidelines cannot supersede a policy. As such, as indicated in the Industrial Policy 2008, investment in plant and machinery or additional investment in plant and machinery for expansion of units and building connected therewith directly with manufacturing process will only be treated as eligible components for computation of fixed capital investment for VAT exemption. The committee also decided that the definition of plant and machinery indicated in the operational guideline is to be modified and necessary corrigendum is to be issued by the government. So it has been given to the government. The corrigendum will be decided by the government, will be issued by the government. So they have, because it's a high-powered committee, Lordship, they have to scrutinize which component is eligible, which component not eligible as per the policy and the operational guideline. Now, as per the policy, Lordship, they have found out that this component is not eligible. So they have a bounden duty on them to point out that this is not eligible. They have to do it, Lordship, because that's a settled law also. So policy doesn't allow that. So operational guidelines, government has brought in some certain components. Now, SLC is a committee which has been formed under the policy. So they have a duty to scrutinize whether the component is allowed or not allowed. Now they have found that this component cannot be allowed because the policy doesn't allow so. So in that context, Lordship, they have taken a decision saying that this has to be referred to the government. So that is why, Lordship, this was denied. And subsequently, Lordship, in 2014 policy, Lordship, operational guidelines, in 2014 operational guidelines, they have rectified it. Yeah, that is there with me, Lordship. They have done it accordingly.
That's
on the basis of the
that's under the new policy, Lordship, not under 2008 policy. Not under 2008
No,
policy.
that is correct. But 2014 policy also same. Policy hasn't been changed.
But the-
Policy definition of substantial expansion hasn't been changed in 2014 policy. That's not there. That is not changed. 2014 policy, operational guidelines in fact brought in. It has rectified this.
Now, what was the order impugned, madam, in your case?
This
Order impugned was in fact different.
Refund,
No,
refund.
please.
Refund,
No, the demand I will ask for a stay
demand for refund.
Yes, yes.
for refund. That and basically the eligibility certificate, order impunity eligibility certificate.
Where is it?
In the premises opposite, setting aside later date and why a writ of mandamus should not be issued directing the respondent number 3 to rectify the eligibility certificate dated this issued to the petitioner by including expenses incurred in electrical equipment installment for this and to give all benefits under industrial policy of 2008, particularly sales tax exempt by computing the fixed capital assets. That is fine. It's basically the policy. So once that is done, the rest will follow.
Here they're seeking for passing of the letter and rectification of this.
Yes, once the rectification done, the letter has to go.
Now, what is this page 28, annexure 5, annexure F?
Lordship, this is they have made a payment of outstanding dues of 13 lakhs. by
No,
the
they
state.
have made a demand for refund.
Yes, because my component came down test, right? My total worked out to 438 instead of 452. Because by excluding that, my eligible exemption came to 438 and not 52. Had electrical installation been there, my exemption would have been 54. So that is a corollary of correction of this.
Yeah.
So Lordship, in the scheme also, Lordship, that scheme that has been like framed by the finance department, there also the definition remains same. Only the operational guidelines also that has created a confusion and that has been corrected by the SLC.
The next one, not
See, so it is there in the operational guide.
Okay. Third, oh no. No, that's it. Third, MS M. Hazari Kalan, Senior Counsel for the petitioner. Also heard Sri A. Kulitalan, Senior Counsel, Industries and Commerce Department, whereas Sri B. Gogoi, Senior Counsel. Who are 3 and 4? You don't have much role. Full stop. Sri B. Gogoi, Senior Counsel, Taxation Department, as well as Sri S. Das, Learned Counsel for the AIDC, are also present and heard. The grievance raised in this petition is with regard to denial of incentives under the industrial policy of 2008, which has culminated in the issuance of a letter of a communication dated 22/8/2014, whereby the petitioner has been directed to refund an amount of rupees 13,07,045, which has been termed to be access by the department. Full stop. The grounds of challenge raised in this petition, amongst others, is that the impugned action is unreasonable, inconsistent, and is in violation of the policy and guidelines holding the field, full stop. Para. Before going to the issue which has arisen for adjudication, comma, the basic facts pertaining to this case may be narrated briefly. Para. The government of Assam had, it was not announced, I think it was adopted. It was a central government scheme.
No, it's a state government.
Had announced
2000.
an industrial policy of in the year 2008 to give certain incentives to new as well as existing units which were undertaking substantial expansion. Full stop. As per the said policy, comma, such units would be entitled to sales tax exemption of 100% of the fixed capital investment and 90% in case of some small scale. No. Small scale is 100%, isn't it?
Yes.
Full 100%, full stop. The petitioner but the petition number 1, which is a private limited company, claims to have an industry pertaining to what? What do you do?
Steel, MS rod.
Pertaining to manufacture of, you call it MS rod?
Yes.
MS rod. And also claims to be a small scale industry. Full stop. According to the petitioners, comma, since the petition number 1, how many petitions are there? Fulfills all the eligibility criteria, had submitted and applied for such exemption and incentives. And accordingly, full stop. After examination of the credentials and the documents, comma, an eligibility certificate was issued on 12/7/2010 for a total amount of rupees 452.16 lakhs, which included an amount of rupees 63,52,117 being the component under electricity installation other than drawal of power line. Full stop. Since the aforesaid assessment was done by construing the petitioner not as an SSI, comma, the petitioner number 1 had submitted representation for treating the same as an SSI unit and not as a medium scale unit. Full stop. Para. With regard to the said issue, comma, the petitioner had earlier approached this court by filing a writ petition, WPC 5421 of 2013. Full stop. This court wide order dated 19 2014 had, after recording the submissions and on consent of the rival counsel, had directed the respondents to do a rectification exercise expeditiously. Rectification exercise, full stop. For ready reference, comma, the relevant part of the order dated 19/2/2014 is extracted herein below, page 20, 80 paragraph. Subsequent thereto, comma, our rectification exercise was done by treating the petitioner as a small-scale industry, full stop. However, while making the assessment under the component of electrical installation other than drawal of power line, comma, the additional investment made for substantial expansion was held to be nil, full stop. Accordingly, comma, the petitioners were issued with the refund notice dated 22/8/2014 as mentioned above, directing them to refund an amount of rupees 4,38,87,837 / full stop. It is the legality and validity of the aforesaid action which has been questioned by the petitioners in the instant case, full stop para. Ms. Hazarika, the learned senior counsel, has submitted that once the assessment was made and the unit was held to be entitled for the amount under the component of electrical installation other than drawal of power line, as would reveal from the eligibility certificate dated 12/7/2010, comma, there was actually no scope for deducting the same in the impugned assessment made on 23/6/2014, full stop. It is submitted that the exercise for reassessment, the exercise for reconsideration as directed by the order dated 19/2/2014 by this court should have been confined only to the aspect as to whether the petitioner, number one, be treated as a small scale unit or a medium scale unit. And once the authorities had come to the conclusion that the petitioner, number one, is a small scale unit, comma, the authorities were not entitled to look into the other aspects of the matter, which were already examined and held to be entitled to by the petition number one, full stop. para. The Learned Senior Council has referred to the notification of the Industries and Commerce Department, whereby the policy has been laid down. Full stop. Clause 7.1 deals with tax incentives, wherein fixed investment has been defined. Full stop. By referring to chapter 12 of the policy, comma, more particularly clause 12.6 thereof, comma, it is submitted that the said clause contemplates that a set of guidelines, including application forms and procedures for getting various incentives, would be issued separately. Full stop. Reference has thereafter been made to the operational guidelines which has been titled made to the operational guidelines for the industrial within bracket and investment bracket close policy of Assam 2008, which were framed under the provisions of chapter 12.6 of the policy. Full stop. With regard to the subject which is relevant for the present case relating to investment in plant and machinery, equipment, comma, it has been submitted that such investment would mean, amongst others, the price for utility installations, including dedicated transformer, comma, gas producer plant, comma, power generating set, etc. Full stop. The expression fixed capital investment has also been explained in the said guidelines to mean and include investment in plant and machinery, equipment, or additional investment in plant and machinery, equipment, and civil construction works connected directly with the manufacturing process, service rendered. Full stop. It is submitted that the initial exercise for working out the incentives which would reveal from the eligibility certificate dated 12/7/2010 would clearly reveal that the amount in question was worked out by excluding the component of drawal of power line and was confined only to electrical installations. Full stop. By referring to the affidavit in opposition filed by the respondent numbers 1, 5, and 6 dated 15/5/2019, comma, the learned senior counsel has referred to the minutes of meeting of the state level committee held on 31/5/2010. Full stop. The discussion of the said committee would show that a finding was arrived at that the operational guidelines cannot supersede a policy, and therefore the assessment earlier made was deemed to be erroneous. Full stop. The committee thereafter had made a recommendation for modification and issuance of necessary corrigendum in the operational guidelines. Full stop. Para. Ms. Hazarika, the London Senior Counsel, submits that the aforesaid observation made by the state level committee dated 31/5/2010 does not clearly does not seem to have been acted upon, inasmuch as the first eligibility certificate is itself dated 12/7/2010, which is after the aforesaid meeting. Full stop. Accordingly, she submits that the impugned action for impugned action demanding refund on alleged excess amount is unsustainable in law. Full stop. Para. To fortify her submissions that guidelines of the government are binding in nature, comma, the learned senior counsel has referred to the following cases. Act number 2003, 7 SCC 301, Delhi Development Authority ... Number 2, 2009, 13 SCC 758, Swaran Singh Chand ... Para. In the case of Delhi Development Authority, Supra, comma, the Honorable Supreme Court, while dealing with policy decisions, with the aspect of policy decisions, had made the following observations. Paragraph 10, quote. Para. Though the case of Swaran Singh Chand pertains to the subject of a compulsory retirement, comma, it has been clearly laid down in paragraph, where is it? Paragraph 9, that the guidelines issued by the state are binding on it. Full stop. Para. The learned senior counsel accordingly submits, has informed this court that while issuing notice of motion on 18/9/2014, comma, an interim order was passed directing, restraining, making of any recovery. And the same is holding the field. Full stop. Para. Per contra, comma, Sri Kolita, the learned standing counsel of the department, has submitted that the first eligibility certificate, that while the first eligibility certificate was issued on 12/7/2010, comma, the objective of the policy was not looked into minutely, and by error, comma, the unit was held to be entitled to the incentive of electrical installation other than drawal of power line. By full stop, by referring to the definition of fixed investment, comma, he submits that such installation would not come within the definition, and therefore the policy would not allow a unit to be given incentive of the above nature. Full stop. He clarifies that so far as drawal of power line is concerned, comma, the unit has already availed of the incentives, which has been quantified as 25%. Full stop. Para. With regard to the minutes of the meeting dated 31/5/2010, comma, the learned standing counsel has submitted that it is the policy which is the substantive law, and guidelines which has been notified in terms of the policy cannot supersede the substantive law. Full stop. He further adds that even if the guidelines may take the color of a delegated legislation, comma, the said guidelines cannot be taken into consideration for matters which are directly in conflict with the policy. Full stop. He submits that when the policy does not provide for such incentives, comma, by the guidelines, comma, providing of such incentives is not permissible. Para. Supporting his submission, comma, Sri Kolita has relied upon the case of State of Odisha versus so-and-so reported in 2007, 8 SCC 189. Full stop. Para. The learned standing counsel has further added that in terms of further added that by the minutes of meeting dated 31/5/2010, a recommendation was given to the department, which was in fact acted upon, and subsequently, there was modification in the operational guidelines.
This operational guideline,
2000
it's a 2014 policy.
We'll record it, operation guidelines. In the year 2014,
framed under 2014.
policy framed framed in the year 2014. Full stop. Para. Sri B. Gogoi, learned standing counsel.
One post officer lordship I kindly add that on the face of this cattle law, whether, I submitted that SLC couldn't have allowed this, the face of this. That part of submission.
Okay. He further submits that the law being clear on the aspect, the state level committee, the decision taken by the state level committee cannot be faulted as a guideline cannot supersede a policy. Cannot be faulted with. That's what B. Gogoi. Sri B. Gogoi, learned standing counsel, finance taxation, finance taxation department has endorsed, while endorsing the submissions made by Sri Kolita, has further submitted that mere issuance of an eligibility certificate is not the end of the matter, which is required to be followed by an entitlement certificate, and therefore, while examining the aspect of the matter, an observation be made that with regard to the issuance of entitlement certificate, the same should be done strictly in accordance with law. Full stop. He has also referred to the Assam Industries within bracket tax exemption bracket close scheme of 2009 to support his submission with regard to the aspect of substantial expansion. Full stop. Para. The rival submissions made by the learned counsel for the parties have been duly considered, and the materials placed before this court have been examined. Full stop. Para. The issue involved in this case is necessary to be examined from the context of the first approach of the petitioner to this court by way of filing WPC 5421/2013. Full stop. The grievance expressed in the earlier writ petition, which would itself be discernible from a reading of the aforesaid order, is that while making the assessment, the petition number 1, instead of being treated as a small enterprise, was treated as a medium enterprise. Full stop. This court had also recorded that the remand was to be made. No, that the remand was made on consent of the parties to do a rectification exercise within a particular period. Full stop. The order of remand being confined to a particular aspect, that is, as to whether the petitioner unit was a small scale unit or a medium scale unit, comma, it is actually questionable as to whether any other aspect could have gone into on such remand. More so when the assessment done while issuing the first eligibility certificate dated 12/7/2010 was otherwise not the subject matter of any challenge. Full stop. The first eligibility certificate dated 12/5/2010 clearly reveals that towards electrical installation, towards the component of electrical installation other than drawal of power line, as stated in serial number 4 within bracket G, an amount of rupees 63,52,117 was assessed as additional investment made for substantial expansion. Full stop. There is no issue raised by the respondent on the factual aspect of the matter regarding such additional investment. Full stop. The present controversy has arisen only while issuing the second assessment order, the subsequent assessment order pursuant to the remand order of this court, where the component under the component of electrical installation other than drawal of power line under serial number 4G has been held to be nil. Full stop. The orders, the eligibility certificate dated 23/6/2014, the second eligibility certificate dated 23/6/2014 does not state any reasons as to why the aforesaid, as to why the petitioner unit was held not to be entitled to any amount under the aforesaid component. Full stop. The explanation, the grounds for such action can be traced back to the state level committee meeting held on 31/5/2010, wherein it has been held that operational guidelines cannot supersede a policy. Full stop. Para. This court finds force in the submission made by the learned senior counsel for the petitioner that the first eligibility certificate itself, which is dated 12/7/2010, is after, was after the minutes of meeting which was on 31/5/2010. Full stop. This court further is further of the opinion. This court further whether a state level committee would have the jurisdiction and competence to question an operational guidelines framed under the policy itself is itself a question, is itself an issue, is itself a debatable issue. Full stop. In any case, the operative part of the observation is a recommendation to rectify the operational guidelines by issuance of necessary corrigendum. Full stop. Para. There is no manner of doubt on the part of this court that a state level committee will not have the competence to declare an operational guidelines as invalid. Full stop. It is a different matter. It would be a different matter if such guidelines was rectified by the competent authority, which in this case was not done at the relevant point of time. Full stop. Para. So far as the submission made by Sri Kolita, the Learned Standing Council, that such change was made in the OS in the year 2014, Ms. Hazarika, the Learned Senior Counsel for the petitioners, has clarified that the policy was that the policy of 2014 is different from the policy of 2008, and the operational guidelines pertaining to the policy of 2014 would have no connection for the subject matter in dispute. Full stop. Para. The decisions referred to on behalf of the petitioners is with regard to the binding effect of the guidelines framed by the state. Full stop. Para. So far as the decision of Tata Sponge referred by Sri Kolita is concerned, the facts of the said case are wholly distinguishable from the facts of the present case. Full stop. In the said case, the grievance was raised by the SSC, which had alleged that by issuance of a subsequent guidelines, the substantive part of the policy by which the unit was claiming incentives was thought to be taken away. Full stop. Under that context, the Honorable Supreme Court has held that our guidelines cannot supplement the policy. Full stop. The Honorable Supreme Court had also made an observation to the following effect in paragraph 22, whereby it has been held that an exemption notification must be constituted liberally. Full stop. Para. In the instant case, this court has noticed that it is the case of none of the parties that the guidelines, that the operational guidelines was oblique is the subject matter of challenge. Full stop. This court is of the view that the guidelines which have been framed, which were framed under chapter 12 was only to supplement the policy and make it workable. And unless such guidelines was existing, comma, it was the obligation of the authorities to follow the same. Full stop. This court has also noticed that while the state level committee had raised questions on the guidelines, comma, the committee had only recommended for modification of the guidelines, and by mere recommendation, comma, the efficacy of the guidelines cannot be held to be obliterated. Full stop. Para. In view of the above, comma, this court is of the unhesitant opinion that the action, that the decision-making process to exclude the petition number 1 from the incentives under the component of electrical installation other than drawal of power line cannot be held to be justified. Full stop. Consequently, the impugned demand notice for refund dated 22/8/2014 is set aside, and the petition unit is held to be entitled for an eligibility certificate, which includes the incentive amount under the aforesaid head. Full stop. This court has also noticed that there is an interim order dated 18/9/2014 passed by this court regarding restraining any recovery, and accordingly the aforesaid interim order is made absolute. Full stop. Writ petition accordingly stands allowed.
Apply.
What about the Mr. Gogoi, please give details of this book. We will have it here in the name to রাখি থৈ দিব।
Item 5.
কোনটো?
Type is subject, but check the profile of Bakalat. The council name are Chakraborty.
Okay, you are no longer appearing for the management.
What?
Any new council? Okay. You're for the workmen. What is the award about?
Award was against the reinstatement. So he was dismissed from the service, and that was upheld by the award by only by going to the inquiry report. So yesterday's case.
Again, fairness of the domestic inquiry.
Same thing, and same judge.
Okay. Is the unit existing?
That I can't say when I have to connect.
What is the name of the respondent?
Noloni Tea State.
Where? Tinsukia.
In Chukia.
Management of Nolboni Tea Estate. We'll do one thing, we'll take a chance, we'll take, ask the registry to issue a notice. Did you issue notice, madam, to the, have you brought it on record? Or- Hmm? Office note আছে নি? কি বললে? Withdrawal. Okay. Okay. Oh. Good difference. Do no, Hard 3A Dasgupta learned senior counsel for the petitioner. Your name, madam?
Aring type it.
Give your name in a slip, okay? Has informed this court, has however informed this court that though her senior Sri P. Kotoki with another colleague had appeared for the sole respondent, comma, the wakalatnama was withdrawn. Full stop. Apart from an office note dated 28/11/2023 in this regard, comma, this court has also passed an order. Same day office name. Same day office note or order huh? Court to tell order get a pass 28/11. 28/11. It's 28/11. 28/11. There is also an order of this court. Ki kol last ni? Passed an order in this regard regarding the withdrawal of the wakalatnama. Full stop. Para. Though this matter is of the year 2014, comma, in the interest of justice, comma, registry is directed to issue a notice to the respondent intimating the aforesaid facts. Full stop. Registry is also directed, full stop, facts. List this case after 3 weeks from the date of issuance of such notice with an office note regarding service. Para. Registry is also directed not to reflect the name of Sri P. Kotoki and Sri R. Chakraborty as counsel for the respondent.
We need not take any steps.
No, registry will take. 2014 matter will not burden you to take steps.
Actually, I don't have the connection with my client. Also.
That is, we have.
Item 6.
That I have for the petition amendment.
Other side,
My lord, I could not contact him, but earlier occasion, my lord, he informed us that brief has been taken away from him. Please,
none is appearing, then we'll proceed ex parte. Yes, what is your case?
my lord, this application is against an award, my lord, passed by Industrial Tribunal 1.
You are the workman.
Yes, ma'am. I am the Sangha representing the workmen.
This application is against award dated 8/8/2013.
8,
8/2013.
which labor court?
Industrial Tribunal, Guwahati.
Okay.
In brief, my lord, what happens here? Management refuses to pay SKC a part of bonus. The workman, my lord, for the accounting year 2007-2008. And 16 tea gardens were before the learned tribunal, my lord. And during pendency of the matter before tribunal, my lord, out of 16 gardens, 11 gardens enter into bilateral agreement and settle the matter out of court.
Under 18.
My lord, out of my lord, 16 garden,
No,
11.
no, is it under 18? Settlement under 18, section 18?
No, it is their bilateral agreement, my lord, between management and
Administrative Tribunal Act.
between management and
No, what is the, have you see, obviously you know the implication of a settlement under 18. It will be binding under all.
it is directly not under section 18, my lord. I will take your lordship, and that agreement was before the tribunal, my lord.
No, no, you just read section
Yeah,
18.
I will. Section 8. Persons on whom settlement and awards are binding. A settlement arrived by agreement between the employer and workman, otherwise than in the course of conciliation proceeding, shall be binding on the parties to the agreement.
Then,
Subject to the provisions of subsection 3 and industrial award, which has become enforceable, shall be binding on the parties to the agreement. Here, my lord,
number three.
a settlement arrived in the course of conciliation proceeding under the act,
Under this act.
For an
Or-
arbitration award in case where a notification has been issued under section 3A of section 10A, or an award of a labor code, industrial tribunal or national tribunal, which has become enforceable, shall be binding on all parties
All the parties to the industrial
industrial
dispute. Number B, all other parties.
amount to appear in the proceeding in parties to the dispute, unless the board, arbitrator, labor court, tribunal, as the case may be, records the opinion that they were so summoned without proper cause. C, where a party referred to in clause A or clause
Come to
B,
D. C is for employer. D
where
is for
any party referred to in clause A or clause B is
composed of workmen.
All persons who were employed in the establishment or part of the establishment, as the case may be, to which the dispute relates to the date of the dispute, and all persons who subsequently become employed in that establishment or part. It is binding. But my lord, here, in this agreement, my lord, that is before your lordship, my lord, that is Annexure 7,
Page.
page 7.
Not 7. Cannot be 7.
7. The statement I have made in page,
Oh, your pleadings.
yes, sir. Page 7. I'm
Okay,
reading.
please read. Paragraph. Page 7, paragraph.
Paragraph 9.
Yes, please read.
That it may be pertinent to mention herein that various management have been paying bonus as per bonus act, and as a gesture of goodwill from maintaining healthy industrial relationship, as have been paid to the members of the petitioner Sangha as ad hoc compensatory relief who are not eligible to get bonus under bonus act by entering into various bilateral agreements from time to time between the management and the Sangha. Paragraph 10. That it may be pertinent to mention herein that during pendency of the dispute before the learned industrial tribunal Guwahati, the management of 11 tea gardens, performer respondent number 7 to 17, involved in the reference, have entered into bilateral agreement on mutual understanding between the petitioner Sangha and individual company or garden, and finally resolved the issue of bonus ex gratia for the financial year 2007-2008 by providing ex gratia as ad hoc compensatory. And this agreement I have annexed, my lord. Well, what happens? This agreement, it details, my lord, happened during the pendency of the matter for tribunal. And tribunal aware of it, but no discussion regarding this agreement and passed the impugnment. So, this agreement, my lord, 11 gardens, my lord, entered into agreement, but planted tribunal, my lord, absolutely silent on this.
Let us see the one of the agreements,
Annex 7,
page.
page 57. Annex 7 is, my lord, most of all the agreements I have annexed. It starts from
But,
page 45.
madam, one thing, you represented the Sangha.
Yes.
You are Sangha for all the tea gardens.
Tea garden.
And now you say that performer respondent 7 to 17,
Yes.
that means around,
Yes.
they have entered into bilateral agreements
Yes.
with the Sangha itself. But
Yes.
this
Yes.
agreement would involve the workmen who are employed in those gardens,
Yes.
isn't it? But the Sangha takes up espouses the cause of all the. Now, won't that be binding upon you?
Not that I will.
You can go for enforcement of the awards of the settlement.
No, yes, I will examine that aspect. My lord, but my submission to your lordship now, my lord, is that, my lord, as because, my lord, the award is purpose, my lord, they did not consider the submission regarding agreement entered into. So your lordship may demand the matter back, my lord, to the industry and to the tribunal.
Now, for that, we have to examine the validity of the award. We'll come back at 2 o'clock. The impugned challenge is held to be without merits. However, it is directed that for all future process undertaken by the directorate for supply of similar nature are to be done strictly in accordance with the act and the rules governing the field. Petitions according to this are disposed of. Kindly take back the records.
Yes.
Records can Didi. Letter.
6 seconds.
May petition. My lord, I want to take your lordship to page 6, my lord, paragraph 7 and 8 of my petition.
Page 6.
Page 6, paragraph 7. That notices were issued to the petitioner as well as to the respondent. The petitioner Sangha as well as management appeared before the learned tribunal and filed their respective written statements. However, after filing of the written statement, the management neither appeared before the learned tribunal nor adduced any evidence. Thereafter, my lord, paragraph 8, that the petitioner Sangha in
Let us read the award.
Yes. At page 79.
7-9.
There is no discussion of the issue involved in the award. It's silent, absolutely silent. The government of the government of Assam referred this case to this tribunal for adjudication. I think notification dated 4/8/10 by framing the following issue. Schedule of the issues given below. Whether the management of this state are justified in refusing to pay ex gratia part of bonus of the ex gratia paid on gross income of workers for the accounting year 2007-2008, particularly in view of the agreement between the CCPA and the Workers' Union of West Bengal. If not, whether the workers are entitled to get ex gratia part calculated on the gross income of the workers for the accounting year. On getting the reference letter, a case was registered by reference case number 1 of 10. The notices were issued to the petitioner and the opposite party to come before the tribunal to contest the case by filing written statement. To assert their plea, the management side had Panpai Tea Estate, Sinharia Tea Estate, Sapoi Tea Estate, so the tea gardens, my lord. They filed their written statement to contest the case. At the same time, Union by Assam Commercial Council filed their written statement to contest the case as per their demand placed before the management. From the written statement of the management, it is found that it is stated that the petition for SKC as filed by the petitioner is unmaintainable, as there is no legal binding on claiming so on the basis of agreement entered in West. So this tribunal cannot adjudicate the industrial dispute under section 10A3 of the IT Act 1947 due to peculiarity of situation in Assam. It cannot be compared with West Bengal. It is also pleaded that Assam Commercial Council does not have the right to raise the dispute of more bonus from the 16 tea state of Assam, comparing them with the tea state of West Bengal. It is also pleaded that in the eye of law, there is no dispute exists in between the parties. It is also pleaded that the government should not refer the case for adjudication. It is also pleaded that it is denied that non-payment of SKC bonus to the workers of the tea state for the accounting year 2007-2008. It is pleaded that bonus etc. cannot be given on the basis of agreement in between the CCP and the Workers' Union of West Bengal. And it cannot supersede the bonus act from any angle, and the bonus act is binding, but not the agreement of anywhere. It is entered as alleged by the union. It is pleaded that bonus is given according to the allocable surplus of the income of the tea state for a particular accounting year in question. It is pleaded that Panbari tea state is given 8.8 SKC during the accounting year 2007-2008, and Sinharia tea state is given 1% SKC, the workmen during the accounting year 2007-8. It is also pleaded that Sapai tea state is given 6.67 SKC to the workers during the accounting year 2007-8. It is also pleaded that Monmohanepur tea state is paying 9.67 SKC to the workmen during the accounting year 2007-8. At the same time, it is also pleaded that Hukrijuli tea state they gave 6.67 SKC to the workmen during the accounting year 2007-8. It is also pleaded that Tekiajuli tea state is given 10.67 SKC to the workmen during the accounting year 2007-8. It is also pleaded that Samgiri tea state paid 9.67 SKC to the workmen during the accounting year 2007-8. It is also pleaded that by the management of Narayanpur tea state, they have paid 9.67 SKC to the workmen during the accounting year 2007-8. It is also pleaded that Durung tea state they gave 9.67 SKC to the workmen during the accounting year 2007-8. It is also pleaded that Tulip tea state is given 9.67 SKC to the workmen during the accounting year 2007-8. It is also pleaded that Belfry tea state is given 8.67 to the workmen during the accounting year. It is also pleaded that Hirajuli tea state statement has been it is quoted my lord.
Yes.
Thereafter, I will take your lordship to last paragraph. It is also pleaded that as gesture payment to the workman, it is the discretionary right of the management within certain limit. It is pleaded that all 16 tea states they have paid bonus according to their financial capacity. It is stated that Assam Commerce Council they do not have right to claim SPSI as per Memorandum of Settlement of Kolkata, the agreement between CCPA and the Workers' Union of West Bengal. And it is also pleaded it is not enforceable on the management. Therefore, it is pleaded to reject the petition by rejecting the reference, holding that there is no dispute to give effort. At the same time, the union filed written statement to contest the case. It is pleaded that they are traded and they demanded SKC bonus for their members for the year 2007-2008 in view of the claim that their salary being far more than the maximum eligible limit of bonus act. So they demanded separate calculation of SKC component only. It is also pleaded that payment of SKC should be free from limit of calculation as mentioned under the bonus act as component to SKC. It is also pleaded that it is a fact that different tea gardens have given different SKCs, especially the tea garden of Sunitpur and tea gardens neighboring West Bengal, given more bonus to the workers. it is also pleaded that management should give some compensatory payment in addition to statutory bonus tax to the workmen as per provision of bonus tax. It is also pleaded that compensatory payment is divided into 4 groups. My lord, here, my lord, our case is that, my lord, for out of 16, my lord, 11 gardens, my lord, they have agreed, and they entered into an agreement, my lord, and they settled their matter. And that was that agreements were placed before the learned tribunal, my lord. But learned tribunal, my lord, did not consider. There is no reflection of that of those agreements in the so the award is, my lord, purpose. And that is, I have stated in my petition, paragraph 10, page 7. I have stated that 11 garden entered into a bilateral agreement, my lord, and they have settled their matter. And our limited prayer was, my lord, to consider my lord case of this 5 garden for a direction that was not reflected in the award. And this agreement for Annexure 7 series. There is no reflection of this agreement that is submitted for the tribunal matter. CPI is a CPM is a consultative committee of tenant association, apex body. And all the management organization is under this apex body, CPA, consultative committee of tenant association. That is, I have given in paragraph 8, page 6.
Now, since you are challenging the award, you have to only by taking into consideration that during the award, 11 out of the 6 gardens have settled the matter.
Yes.
By not taking into consideration that aspect, the award does not become bad. You have to challenge the award on your own merits. First, you have to establish that your entitlement to bonus is a matter of right. To us.
Here, my lord, my submission against the award is that it is perverse, my lord.
Purpose for what?
Purpose for, my lord, not considering this agreement, my lord. That is.
How can it be perverse?
And
Out
it is
of
also
16
illegal.
gardens, 11 gardens, they agreed to come to a settlement.
Yes.
For not taking that into account, let the award become perverse. The award has to answer the reference. Reference is on a very confined issue, whether the management is justified in refusing to pay bonus.
Yes. Whether the workers are entitled to get SKC part calculated on the gross income of the workers for the accounting case.
Now, for not taking the settlement, how can it be perverse for that purpose? First, you have to show that you are entitled to bonus. And before that, what is bonus? How is it calculated? It is obviously calculated on the gross income of the unit. Bonus cannot be a matter of right. It's an ex gratia.
But for paying bonus, my lord, in every year, my lord, it is an agreement entered between the parties.
Now, if there is an agreement, you do not raise a dispute. You can go for enforcement of the agreement under Section 18. Settlements are binding on all parties.
No, my lord, yes, my lord. For 11 gardens, my lord, there is no issue, my lord. They have settled their matter.
No, to challenge this award, you have to make out independent grounds. What are your grounds?
Paragraph 14, 15, my lord. My lord, 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 my l 16, my lord, that a learned tribunal made the impune award, totally ignoring the application filed before a tribunal, informing the fact as to entering into agreement between the petitioner Sangha and the concerned management, resolving the dispute, referred to the tribunal, and therefore it is purpose.
Now, you have said that out of 16 guardians, 11 have entered into agreements.
And that
Then rest remaining 5, it's up to the parties. You belong to different guardians.
belong to different.
The owners are
Management.
different. Out of 16 owners, 11 have agreed to settle the issue. Good. The issue remained to be settled for 5. 5, you have to fight it out in the tribunal, which you have done. Tribunal has given a finding against you. If you are aggrieved, you have to make out grounds. Payment of bonus act we have examined. There is no definition of bonus.
There, my lord, what happens, but earlier, my lord, there is a, my lord, ceiling, my earlier it was 3,500, in 2017 it was 10,000, and now it is 21,000, my lord, per month. And those who beyond the limit, my lord, the calculation has been made, my lord, it is a ex gratia payment. It is out of petition, my lord. There is, it is not there in the act. It is out of petition, my lord. And those who
Now, out of once you say it's ex gratia, it's a case, it's
It
an
is-
act of grace. Then
No,
you have to
it-
show
it-
some right that you are entitled
no, it
to
is
it.
the custom in the garden matter. It is not in the Industrial Dispute Act. I will take your lordship to section 10, my lord,
Of
Industrial Dispute Act.
10 is reference.
8, my lord, I'm sorry.
8.
8. I will take your lordship.
Eight is filling of vacancies.
No, I will take your lordship. Just a- I will take your lordship to section 10 of the Payment of Bonus Act, 1965.
Yes.
Payment of minimum bonus. Subject to the other provisions of this act, every employer shall be bound to pay to every employee in respect of the accounting year commencing on any day in the year 1979, and in respect of every subsequent accounting year, a minimum bonus which shall be 8.33% of the salary or wages earned by the employee during the accounting year, or 100 rupees, whichever is higher, whether or not the employer has any allocable surplus in the accounting. Provided that whether an employee has not completed 15 years of age at the beginning of the accounting year, the provision of the section shall have effect in relation to such employee. As if for the word 100 rupees, the word 60 rupees were substituted. And section 11, payment of maximum bonus, where in respect of any accounting year referred to in section 10, the allocable surplus exceeds the amount of minimum bonus payable to the employee under this section. The employer shall, in lieu of such minimum bonus, be bound to pay to every employee in respect of that accounting year bonus, which shall be an amount in proportion to the salary or wages earned by the employee during the accounting year, subject to a maximum of 20% of salary or wages.
Let us see your written statement.
It is my statutory right, my lord.
Let's see your written statement.
Page 12.
Yes.
The Union of the Commercial Chamber carried after referred to STKs is a registered trade union and is an affiliated body of various trade unions that are commercial in the state of Assam. That the STKs is a recognized trade union by all management of the state in the state of Assam. That the STKs raised an issue for payment of bonus cum SKSA for its member for the accounting year 2007-2008 in view of their claim that their salary eligible earning being far more than that of the maximum eligible limit under bonus act, and they demanded separate calculation for SKSA component only. And a said matter was discussed with various management of these states of SCKs, and SCKs opined that the payment of SKSA should be free from the limit of calculation as mentioned in the payment of bonus act as component exit. Right. That ultimately the matter has been referred for conciliation, and after holding conciliation on various dates, the conciliation officer referred the matter to the appropriate government for making a reference. It is pertinent to mention here that during the conciliation officer issued notices to all the concerned states mentioned in the order of reference as a demand are common to all the employees of these states in the district of Sunitpur, and accordingly the appropriate government by notification number so and so dated 10/8/2000 referred the matter for adjudication on the issue. Whether the management of the tea state as listed below are justified in refusing to pay SKSA part of bonus SKSA paid to the worker on gross income of the worker for the accounting year 2007-2008, particularly in view of the management agreement is between the CCP and the workers union in West Bengal. If not, whether the workers are entitled to get SKSA part calculated on the gross income of the workers for the accounting year. The following are the managements involved in order of reference. That is, my lord, 15 gardens are involved, my lord. That except these states mentioned above, the district of Sunitpur, all of our tea states run by various companies have already settled the matter bilaterally at the instance of the state conciliation officer cum labor commissioner Assam. The other tea companies having tea gardens in Tezpur subdivision in the district of Sunitpur were also invited by the conciliation officer, but except 4 tea states, none appeared. And therefore, notice were issued to all the tea states of Sunitpur district as mentioned in the order of reference by memo number so dated 11/11/2009. However, the matter could not be settled during the conciliation amicably, and as a result of which, the conciliation officer had to submit his failure report under section 12 for the industrial. The management did not appear, but therefore agreement could not be arrived at. That in this connection, it may be mentioned here that in the beginning, a neighboring state of Assam, it is West Bengal, there are several tea states run by different companies, and the same issue was involved in the order of reference, and the management of the different tea companies of West Bengal discussed the matter with the management of different tea states. Those tea plantation in West Bengal and the different tea trade unions of the state in West Bengal. That in the state discussions, as many as 35 number of these states represented in the discussion, and the union was represented by 102 number of different unions having registration affiliation under Trade Union Act. The parties to the discussion decided to settle the early and peaceful settlement on the issue of bonus in the tea plantations payable to the workmen of different tea states led by state 102 number of units. The parties settled the matter with the following terms. For the sake of industrial peace and harmony and avoiding loss of production due to other forms of vegetation on this issue, and to compensate the hardship of work due to rise in the cost of living, the management will make some compensatory payment in addition to the statutory bonus payable to the workmen as per provision of payment of bonus act 1965 as amended up to date, including temporary worker on the basis of 12 months earning during the period 1st April 2009 to March 2010 for the purpose of payment of statutory bonus as well as compensatory payment to these states in towards and will be divided into 4 groups. Number 3, in response to the appeal made by the union, it is agreed that where the salary of an employee exceeds ₹9,000, the payment and prices thereafter shall be calculated as his salary was ₹9,000. The above is without prejudice to the contents of the employees and shall be applicable only for the agreement. paragraph 8, that it may be mentioned here in that all earlier occasions, that is previous accounting year, the management of different tea estates, including the present tea estate, involved in the order of reference, paid bonus and SPSI in order to foster harmonious and industrial relations between the management and I. Only these 5 guardians, my lord, no payment has been made. That is my statutory right. That is, and management, my lord, after filing W, as they did not appear, my lord, no evidence, no document applied. They just remain silent.
And what about your evidence? Did you adduce evidence? Then,
It's in my lord, 75 documents. Paragraph 9, that it is pertinent to mention here that there is an organization known as Consultative Committee of Planters Association, that is CCPA, which is the apex body of India, relating to management of tea gardens located in different states in India. The organization like Assam, branch of Association, Tea Association of India, Brahmaputra Sahapurijan, Assam Tea Planters Association, all the associations are, they are members of CCPA. Right? That CCPA entered into a memorandum of settlement on 18/9/2010 between the different trade unions concerning the tea garden in West Bengal. And in that memorandum, the settlement, it was agreed that the statutory bonus as well as compensatory payment of the estate in Duars and Tarai in West Bengal have been divided into 4 groups and they were paid by them. But in Assam, they
madam,
did
in
not.
this case, on one occasion, somebody had appeared for the management and submitted that affidavit has been filed. Have you received a copy of the affidavit?
Okay.
No. Thereafter, we directed connecting this affidavit with the records. The registry has put a note that there is no affidavit found.
Copy, I would have received my lord.
Who's the counsel? P. Sundi.
Please don't be my.
Where is he? Mr. Kolita? No. Not for several months. Brief has been taken back. Can you get this information concrete? Then we can get the views of the management. You can issue, ask the registry to issue notice and fix a date, just like the last case. Can you just get back to us if it's really? Because since evidence are not there, neither by you nor by the management, and would like to at least, since somebody has appeared, the affidavit is also not with the records. After a while, madam, let him come back.
I didn't say that.
My name is not on record, but I'm appearing on behalf of the. In this case, case is led by senior counsel, Mr. Pitzer, but not.
What is the matter about?
Lordship, I appear to respondent. The writ petition is against an attachment order of the petitioner's tea estate. The attachment is to recover Provident fund dues
Okay.
from the employee.
You
The
appear
employee.
for the Provident authorities?
Yes, Your Lordship.
Okay.
So there has been dues since 1977 that has not been paid by the management,
Okay.
and therefore there was an attachment under the Act. That's a power given to us to recover. Lordship, the matter is of 2018. There is this no coercive action against in their favor, which they're enjoying.
IA4?
No,
IA4?
Lordship, in that background, we moved an IA in 2022 for reconciling. Basically, the contention essentially in the writ petition is the figure in the attachment order is not correct.
Okay.
They say that we say 88 lakhs is due.
Yes.
They say, no, we paid some 15 Benami, something, etc.
Okay.
Initially, when the writ petition came up, Honorable Court tried to make us sit together, which is reflected in the orders, and reconcile. That didn't happen. When that did not happen, it prompted us to file an application for a retired judge who will reconcile. And Lordship, this is pretty much like the separate committee, which is pretty much it is under the act.
Thereafter, was any
That,
order passed?
Lordship, nothing. It's been adjourned. So, Lordship, my prayer is this, that IA, because whether even if they win in their writ petition, they have to pay. Question is not about whether they have to pay or not. The liability is not in dispute. It's a mandate. It's a statutory mandate. Question is, what is the amount? If that be so, let there be this. We can't expect a writ court to go into reconciliation of forms and figure out how much they paid and how much they have not paid. And
Madam,
essentially, Lordship, it's their
When
document.
do you expect your senior to come back?
It's 18.
Lordship, on reopening, because 18 January is
22nd,
perfect.
22nd January?
Lordship,
Or maybe
18th is
20,
Huh? 18th,
18th or 23rd.
23rd,
Lordship, earlier is better,
18th,
subject to Lordship's convenience.
23rd, okay, 23rd.
Tuesday, yes.
Tuesday.
Yes.
And what has transpired that there may not be any requirement since you are not denying your liability, you cannot deny. It's a statutory liability. The denial or the dispute or the issue may be confined to the amount in question. For that, we can, as has been suggested, we can have a committee, one-man committee to sit with the parties, reconcile, and take into account the respective stands and come to a correct finding.
Lordship, that has been a prayer September 20.
And yes, and your eye is there, would consider the eye.
Yes, yes.
Okay.
Lordship, in
A prayer for adjournment has been made on behalf of Sri P.K. Tiwari, Senior Counsel, who has been stated to be unwell. Full stop para. Ms. G. Goswami, Learned Counsel, appearing for the respondent number 1, however, submits that in this writ petition, the connected IA has been filed for constituting a committee to reconcile the account. Full stop. She further submits that the dues being statutory in nature, it cannot be denied to be paid, and it is only the quantum on which there may be some issue which can be sorted out by the committee that may be so appointed. Full stop para. She also expresses an urgency as there is an interim order operating since 2018. Full stop para. Considering the above, release this case on 23rd of January 2024. Full stop. The respondents may also press the I on the next date.
Right.
Item 6.
Yes, anything?
Picking over. He didn't get to the Lordship and he has
He's not appearing. Okay. Okay, we'll do one thing. We'll fix a date. We'll direct the registry to आपने मारा था क्या पीछे हो ना कौन सा ये वाला item number 5 huh? No, it is 6 no 5 और G order से 5 order इनका नाम दे दीजिए ये भट्टाचार्य जी same date वो ना date दिस लो 3 weeks. Okay. You need not take steps. Registry will take steps. Okay. It's a old case. देख लीजिए वो ऊपर थोड़ा चेंज होगा वहाँ ये लोग एप्लीकेशन दिया था ना यहाँ एक होगा मैं करा दूंगा ठीक है
Item 8.
Yes.
My lord, this is a picture of the section 11 of the arbitration.
It is not filed.
This is for only for appointment, isn't it?
Appointment of an
You
arbitrator.
are for whom? NIPCO,
No, for Coal India.
Coal India.
Not in Supreme.
No, in principle, are you objecting to the appointment? Why? Is it not arbitrable dispute?
Is it the not the on our part that the majors mentioned in the laws was not exhausted complete. Without
No, but first,
exhausting
see,
the majors, they can straight to High Court. So lordship can kindly
no,
come-
first, you are not denying that there is any clause, denying a clause for arbitration. There is a clause.
Yes,
There is a dispute which has arisen.
yes.
The disputes till now have not been able to be resolved. You are raising the issue that there are certain mechanisms before even going for arbitration, they can address, they can raise the grievance under those mechanisms.
Before the mechanism.
But ultimately dispute has to be resolved.
But not that the law is settled here by the Supreme Court. That without resorting to the
Clauses indeed.
mechanism mentioned in the clause
Then when can Mr. Ahmed come back?
Yes.
When?
on 22nd.
But can it be on the 18th on reopening or?
He is not well, so let it be on
25th, 25th.
25th, okay?
25th actually we have to difficult not on
No, these are 11
Thirty-
matters, don't
Yes.
take much time. We,
only that the law point that
okay.
that is how it becomes.
Tell us when.
On 30th.
30th.
30, yeah, around, Mr. Sharma?
My lord, 30th.
Those three CP Sharma, London Senior Counsel for the petitioner is present, comma, a prayer for adjournment has been made on behalf of Sri M.J. Ahmed, London Senior Counsel appearing for the contesting respondent numbers 2, 3, and 4. As he is stated to be unwell, full stop para, as agreed to by the parties, list for consideration on 30,
I'm deeply obliged.
31. Please tell us.
Item 9.
May I please lordship, my lord? My lord, the matter pertains to my lord provincial election of services the petitioner. My lord, elementary level school, my lord. Upper primary school, my lord.
Why bench 4?
This was earlier, my lord, taken up by Justice my lord Pathak. Bench 2, my lord. Bench 2, my lord.
Bench 2, it go before bench 2. Please before appropriate bench. One moment.
My lord, earlier
This
there
is
was a direct.
assigned.
It was on the top of the list.
Is this assigned? Assigned. We have to take up. Yes.
Yes, my lord. My lord, issue is very simple, my lord. In this case, my lord,
Why 23 matters are assigned? Why? What is the urgency? Okay, tell us. We'll take up.
my lord.
Yes, what is the matter?
The matter is regarding my lord, provincial election of service of the teachers. If your lordship kindly turn to my lord, last page of the my lord writ petition, page 89, next to 10. That will be very clear.
Page?
Page 89, my lord. 89.
Yes.
The next to 10, my lord. Column
Yes.
number 11, my lord.
Yes.
Additional information, my lord. This is an inspection report, my lord, which was carried out by the district limited Noga.
Date
Dated, my
3/11.
lord, 2/11/2020.
3/11.
The last, my lord, inspection.
2/11.
Yes,
Inspection report.
inspection.
For that matter, I need some time, but I have expect communication matter.
Let me submit.
Has it been sorted out? Has it been
No,
sorted
my
out?
lord. Department has sought some more time for regarding 674 numbers of school. Kindly peruse the order dated 10
In this case,
My
in
lord,
this case,
10 to my lord.
court order,
Court order, my lord. Some report was sought for by the
10,
10 to
2.
10 to 20. So the-
No, that was my lord regarding the status of toilet. Lord, one of the annexure, my lord, that I annexed, my lord, while filing the writ petition, my lord, I could annex the, my lord, the U-Dice code of 2021 and 22. In that, my lord, U-Dice code, my lord, in so far as my school is concerned, my lord, it was shown that no toilet is available in my school. But by virtue of my lord additional affidavit, my lord, which I have, my lord, filed on 25th of my lord July, my lord, it was reflected that, my lord, in the year 2020 and 21, my school is having, my lord, sufficient number of toilets. And again, my lord, in the subsequent year also, the very latest, my lord, U-Dice code, my lord, pertaining to the year 2022 and 23, the school is also having the toilet sufficient number. Therefore, my lord, the issue of provincialization, my lord, is altogether a different issue. My prayer was also, my lord, to consider the case of provincialization of service of the teacher in my school. I fulfill all the criteria. The records are there. I have annexed all the necessary records.
Connected.
You take instructions on the additional affidavit. Since the controversy was also sought to be explained by filing additional affidavit, you take instructions. Heard Sri Jed Hamad Learned Counsel for the petitioners, whereas Sri B. Talukdar Learned Counsel, Standing Counsel has represented
Implemented.
the Elementary Education Department. Full stop. Sarah? Sri Talukdar, the Learned Standing Counsel has submitted that a communication has been issued to him on yesterday, i.e., that is 10/1/2024, by which information, by which it has been stated that the necessary information for 674 numbers of elementary schools is still under process, for which some time is required, for which some time would be required. Full stop. He further submits that the present school is amongst the 674 number. Full stop para. Sri Hamad, the learned counsel for the petitioners, however, submits that the issue of having adequate number of toilets in the school, which was raised on 10/2/2023 before this court and observations made, has been explained by way of filing additional affidavit. Full stop. Para. In view of the above, comma, let the learned standing counsel obtain necessary instructions. Full stop. This case may be listed after 3 weeks. 3 weeks. Full stop. The stand of the petitioners, as expressed in the additional affidavit, may also be taken into consideration while taking the aforesaid instructions.
That's what number.
P
First, we'll
does.
kindly fix the date.
P does for SSU.
Yes.
When do you want on
No, in the second week of February,
on 7th of February?
my lord.
Mr. Talukdar?
My lord.
Okay.
My
Which
lord.
on 7th? You take your instructions back.
Ten to 13.
Well, may I- well, in item number 10, WPC 3958/2020 for the respondent PWD. I was referring to the affidavit in opposition filed by the respondent number 1, 2, and 4. Lordship, kindly take the
Just a minute. Yes.
My lord, kindly take the affidavit in opposition of the respondent number 1, 2, and 4. It starts at page 308.
Three?
308.
Yes, please.
I have taken your lordship to paragraph 4, my lord, and kindly come to page 312, my lord. The other portion on the other day, I'll not to read to read it, my lord.
312.
312. I have already to the earlier part already I have read. There in paragraph 4, we have stated that the annexure 1, 2, and 3 I have referred. Those are the affidavits given by the bidder, and those affidavits contains that the petitioner number 2 herein, he was in his individual capacity, he was earlier doing
Mr.
the
Nath, while you draft your affidavit, why don't you give paragraph numbers? Why should one paragraph be of 3 pages?
this paragraph
Is it
4 is the
no, understood, but if your one paragraph goes to 4 pages, how do you refer to a particular paragraph? See your paragraph 4, how many pages?
4.
What is the difficulty in giving numbers?
I'll take this.
No, these are matters of convenience. It's convenient for you, convenient for the court. You can refer to some pages, we do not know, they will not be able to know. You have to pinpoint, one paragraph should not be of 4 pages. At least we have some subparagraph numbers. Which page are you trying to refer? Which part of the paragraph?
Paragraph 4 starts at page 1309.
Yes.
I'll take your lordship to page 312. 312.
Yes, which part?
The deponent further
Second part.
Second. The earlier part I have taken. And I have also taken your lordship to annexure 1, 2, and 3. Yeah.
Yes. Deponent further.
Yes, the deponent further respectfully states that it was also found that the bidder has concealed one of his ongoing commitments, that is improvement of one Palaigaon Koirabari Road to Nonorilu from so and so to and road from Poop Kotakat to Rajpukuri Approach Road, Poop Kotakat to Rajpukuri LP School under Mukhyamantrir Unnata Pokipot Nirman Asani for the year 2022-2023, which was allotted to Purvanchal Building Private Limited by Chief Engineer PWD. But that we have followed by LOA number so and so dated 10/3/2023. This LOA we have annexed. This lecture dot will find at page 326 annexes. This is the letter of acceptance issued to the petitioner company on 10th of March 2023. The work is for improvement of the road. And this is an existing commitment as per clause of the tender. The existing commitment the petitioner has to in a particular format is there. I have fixed your lordship that method.
Yes.
This has not been. This is an existing commitment, the name of the company. So by this letter of acceptance, the petitioner has been informed that this is to notify that your bid number 17/11/2022 for execution of the work of improvement of Palaigaon Koirabari Road to Nonoirilu from Chinese so and so to so and so, and number 2 road from Poop Kotakat to Rajpukuri Approach Road from Chinese so and so under Mukhyamantrir Unnata Pokipot Nirman Asani for the year 2023 for the bid price of rupees so and so as corrected and modified in accordance with the instructions to bidder is hereby accepted by our agents. This has been given to him, and this is an existing one. Yes, this is issued by the PWD roads in the name of the company. Then this has not been mentioned in the bid. So let's kindly come back to the page 312 reading the paragraph. As per stipulation of the RFP clause 3.2.2.2.1, that is bid capacity, value of B may be noted. B is equal to value updated to the price level of the year indicated in the table note 3 below of existing commitments, work for which the bidder has emerged as the winner of the bids or ongoing works to be completed during the period of completion of the work for which the bid is invited. So we have asked for, in the bid document, we have asked for all the ongoing works, the existing commitments. Suppose this particular work for which the NIT has been issued, the completion period is 6. So within that 6 months, ultimately now an existing work he will be completing the work within 2 months, or he is going to complete the work within 1 year. That is required for to access the bid. So this he has not informed. For the sake of clarification, it is mentioned that work for which the bidder has emerged as the winner of the bids, but LOA has not been issued as on date before opening of the financial bids shall also be considered while calculating the value of B. Therefore, as soon as the bidder is declared as L1 winner of the bid in any tender process, the bidder must count the same work as his existing commitments in all subsequent tendering process. Further, confirmation regarding the concealment of ongoing commitments as mentioned above had been received from the Chief Engineer PWD Road, Chanmare, by this letter number so-and-so dated 24/7/2023. Accordingly, after receipt of the confirmation regarding liabilities of contractor, it was confirmed
that the company concealed their ongoing commitments and misrepresented to the authority, and therefore the company Purvanchal Builder stands technically non-responsive as per resolution as per stipulation of para 2.6.2 of the RF. So that is the reason for his non-responsive. But in paragraph 5, we have 9 that the main allegation is that the technical evaluation committee has arbitrarily considered the technical bit of the petitioner as non-responsive. So we have denied, and we have also explained in paragraph 4, which is a long paragraph, I have read, and we have shown that some existing constituents in the name of the even in the name of the company also here. And the document that annexure 1, 2, and 3 I have referred to that all the existing liabilities, sets, experience, whatever the petitioner number 2 in his individual capacity has. He has given affidavit and he has transferred everything to those are before the authority while evaluating his technical feedback. But in respect of petition number 2, the respondent number 5, in paragraph 5, we have stated that some clarification have been sought, and those have been done. So one vital aspect is also there. Okay. When the interim order was not there, not asked in their favor, they went on appeal. In writ appeal, I have kindly come to paragraph 8. Against the order dated 31/7/2023, they preferred an appeal that the petitioner company has filed writ appeal, being writ appeal number 296 of 2023, against the order dated 31/7/2023, passed in the instant writ petition, whereby the prayer for interim relief made by the appellant in the writ petition challenging rejection of its technical bid in a tender process initiated by NIT dated 11/4/2023 for the works described so and so was denied. The Honorable Court, after hearing the writ appeal by an order dated 23/8/2023, disposed of the writ appeal number 296 of 2023, entirely with an observation that the appellant shall be at liberty to raise all objections before the learned single judge regarding the arbitrariness of qualifying criteria applied to the authorities while evaluating the bids. The Honorable Court has also clarified that the tendering authorities will be at liberty to take recourse to clause 2.6 of the tender conditions for seeking explanation, additional information from the parties if so advised. In view of the Honorable Court order dated 23/8/2023, the respondent authorities have sought for explanation from both the petitioner company and the respondent number 5, and they have submitted their statement. The authorities have already examined and assessed the explanation submitted by the petitioner and the respondent number 5. However, considering pendency of the petition, no final petition has been taken. So, kindly come to the Honorable Court order in the writ appeal at annexure 9, page 328.
328.
320. Annexure 27.
Yes.
It starts at page 329. The order is dated 23/8/2023. But next is kindly come to para 3. The third para, needless to say, the Mr. P.T. Kaur, Lanet Senior Counsel, representing respondent 5, and so submits that it would be better if the writ petition pending for the Lanet single judge is decided on merits, because any comments on the merits of the matter by the division bench in this writ appeal would prejudice the right of appeal of the parties concerned. So and so assured that till the writ petition is decided, the work order shall not be issued to the respondent number 5. It is to say that the appellant shall be at liberty to raise all objections to the Lanet single judge, Lanet single bench, regarding the arbitrariness of qualifying criteria applied by the authorities while evaluating the bids. It is also made clear that in case of failure of the appellants in their challenge to the rejection of the technical bid, all consequences will follow as part of. On the request of Mr. So-and-so, it is further clarified that the tendering authorities will be at liberty to take recourse to clause 2.6 of the tender conditions for seeking explanation, additional information from the parties if so advised. But they have accordingly sought for the explanations, and the parties, the petitioner as well as the respondent of 5, they have already submitted. And they have also considered, but no final order has been because of pending. So, Lord, my respectful submission is not,
Is this affidavit been replied to by the petitioner?
they have replied. They have filed it.
Yes.
Lord, in response to paragraph 4, Lord, page 332, Lord, they have stated that the statement made in paragraph 4 of the affidavit in opposition, the petitioner begs to state the following. In the memorandum of association of the petitioner of one company, it is stated that all credentials, technical, financial experience effect from March 8, 2022 of the petitioner number 2 may be counted for fresh bids and contracts under different state and central organizations as credentials of petitioner number 1. And it is stated that there was no indication that in the said MOA, the petitioner number 1 company, that liabilities of ongoing work in the name of the petitioner number 2 will be that of the petitioner number 1 company. As such, in the humble submission of the petitioner number 1 company is not bound to declare the liabilities of the petitioner number 2 in the bid document.
But that LOA, you have stated that it is in the name of the petition number 1. That LOA.
Yes, madam. That LOA
At
is in the name of the.
322.
Yes, yes. 10th of March 2023.
10th March is in the name of Purvanchal.
It was in the name of the Purvanchal. That was not, they have not.
Disclosed.
They have not accepted.
How was what is the reply to this?
That reply we have given in the affidavit in opposition file of respondent of 5, my lord. And Lordship will find that at page 368, paragraph 11.
Here also they have stated first 336. Page 336.
Is the reply
Paragraph?
paragraph 11, my lord, 368.
Oh, yes.
May I read, my lord?
No.
In this affidavit, at
no,
page 336,
we don't. They are trying to project that the work order was issued after the last date of submission of the bids. So that may not amount to a suppression unless you have the work order in your hand.
LOA was issued earlier.
And my lord,
LOA 10/3/20.
10th of March.
But the
work order was issued on 11.
That is what, my lord, in our affidavit we have said that the moment the LOA is issued, the party is ultimately, my lord, when he is found L1, the offer is given to him, and after his the acceptance, it becomes fine. But the tender conditions provides that they have to indicate it, my lord.
Well, kindly turn to
While-
page 50.
While considering the bid capacity, I have, in our affidavit also that clause we have mentioned, clause 2.2.2.1, while calculating the bid
What
capacity.
was the value of this work? 10/3/2023
10
work.
feet, 10 feet. Well, here, Lordship, kindly see. Value of the work is here 9 crore. 9 crore 36 lakhs 21,006.
Will it make any difference in the bid capacity?
Well, here, kindly see, the issue is not as regards the whatever you will have the bid capacity on. That,
No.
That calculation. Lord,
You are absolutely correct.
Sorry.
Your focus is on the non-disclosure of material
Material.
facts. Whether it will have any effect on the bid capacity, that is a very general principle. But
At
here,
least
in view of the explanation that the work order was issued after the last date of submission, we may give some certain leverage to the petitioner by considering that if this was disclosed, would his bid capacity be adversely affected so that he becomes disqualified?
But that example, I with you. I'll not
See,
put that
suppression of facts is one thing, suppression of material facts is another thing.
Correct.
And not suppression, non-disclosure. Suppression,
We say that the term said misrepresentation.
Misrepresentation is doing something and stating something else. That is misrepresentation. Non-disclosure, suppression do may be of the same meaning, but suppression also has the mental element, and non-disclosure may be inadvertence. Here, he has come up with an explanation that the work order was after the last date of submission.
We say that.
And you say that it doesn't make any difference. The moment LOA is given from that date, if you balance both the arguments, then ultimately we may have to come to the aspect of prejudice. If he would have disclosed this, would his bid capacity be affected, or is this work such of nature that disclosure would lead to his disqualification?
My respectful submission would be, Lordship, before going to that, Lordship will see whether the decision taken by the authority because of non-disclosure of this act, the authorities have acted arbitrarily or they have acted as per the terms of that because while
Mr. Nath, there are two aspects. One is a legal malice, one is a factual malice. There may not be any factual malice. You have acted strictly in accordance with the terms of the contract. Non-disclosure, it has come to. But if you leave the veil, this may not be may not be termed to be of such nature of non-disclosure, which may entail a disqualification. Other than this, what are your reasons?
We have found that
they are apprehending that works done by Motlib, one of the directors, you have taken into consideration. Is that your consideration?
That is one. And the other is that even in the name of the company.
Director, even in the name of the company, there is one non-disclosure.
They have. Not only in respect of the person.
How do you justify one of the directors' previous job?
No, because of his undertaking and all these papers he has given. The documents which are before the authority, the technical committee, they have found that everything has been given to the company. Now nothing is there. In fact, in their reply, they have said.
First, let us again go back to the minutes of meeting where you have
page 140.
140.
140. It starts at page 139. The relevant is serial 3. Purvanchal Buildtech Private Limited, based on the representations received regarding the concealment of existing commitments by the bidder named Purvanchal Buildtech Private Limited, necessary clarifications were requested from the relevant heads of the director, specifically Chief Engineer PWD Border Road. PO letter number so and so dated 25/5/2023. In response, the Chief Engineer PWD Border Road Assam letter number so and so dated 26/5/2023 has confirmed that the bidder did not disclose the mentioned commitments in their bid. This deliberate misrepresentation of facts rendered the bidder liable to be disqualified as
Where is this 26.5?
26.5 is here.
At page 221, affidavit in opposition filed by R5.
Two 21. Mr. Nath,
But
see, 221 is the only document
yes,
which you have considered for.
these are in the name of the petitioner number.
Do you have the records?
So the technical committee evaluation or record is not right.
See,
Right.
we may not go by what your stand is the affidavit. We will go by strictly by the reasons which are mentioned in the order or which may find place in the records. The present work of LOA of 10/3/2023 was never in the mind of the decision making.
Well, that we have in fact indicated in the affidavit.
How can you?
That we have indicated.
How can you?
It was on 14/6. The decision was taken on 14/6.
See, the decision has taken into account only one letter, 26.5.
Yes, yes.
And nothing else.
Yes.
How can you improve your stand?
Well, on 14/6, it is correct. On 14/6 only this 26/5/23 letter was.
That was the only consideration. We have to examine the decision on the basis of the decision taken by the authorities at the time of the decision. You cannot improve by your case by way of an affidavit.
In fact, we have said that the further confirmation regarding further confirmation.
Can you take a further confirmation? You have already taken a decision.
That's
You have to defend your decision on the basis of the factors which you had considered. You cannot improve factors or add factors by way of an affidavit.
in fact, they have further confirmed. After that also they have confirmed on page 313, we have
No,
indicated.
that is the point. On law, can you take into consideration any other factors?
MS Gill. Well, kindly see.
See, this is the only letter of 26/5/2023. Therefore, we want to see from the records whether he had made any exercise, even to the extent that, yes, petition number 2 was one of the directors, we leave the veil and we find that these are also affected, then we can take some view. Otherwise, apart from these 3 works, we are not going to any other works.
Well, on 14/6/2023, when the decision was taken.
Correct.
This is the letter.
This is the only consideration.
Yes. Well, Annex 8, page 327.
327.
327.
Yes.
Annex 8. This is, we have indicated the affidavit that confirmation has been sought as the liability. This they have.
Mr. Nath, can you do that? These are all settled position, 52, page 16.
And 78.
Gordon Das, Bhanji, Justice Vivian Bose.
Public order publicly made has to be construed in the context in which it is made.
It's reiterated in MS Gill, 78.
So in fact, when these things are before the authorities.
No, we are giving you the cue. You can praise the record and say that yes, Motlebuddin is director number 2. We lifted the veil. He is the main person. This you can make some. You can
Yes,
try
yes,
to convince us.
That is
the only avenue left.
That is the only reason. That is the only reason.
If that is the only reason,
Yeah.
try to convince the court with that reason. That these are good enough reasons. But you have to have a heavy burden because these are separate entities altogether. This is not a sole proprietorship firm that Motlebuddin and Motlebuddin Messrs. Motlebuddin is the same person. It's a company having its own legal entity.
Well,
We have the records.
yes.
When?
I'll produce the record.
18th
On 18th.
or 19th? Tomorrow, 18th, I think you can produce.
18,
Tomorrow is a working day.
yes, sir, on 18.
Mr. Chaudhary, we can just inform you.
Yes.
Mr. Nath has taken the further plea that in the affidavit, he has given another work which he have not disclosed, and work where LOA was issued on 10/3/2023, and this work is not pertaining to petition number 2, but to the company. Mr. Deka has shown that this work order was actually of a later date, so there is no material suppression as such.
24/7/23.
24 months after the last date. So he says that LOA is the date construed. Then see this.
We have dealt with that in para 11 of our reply.
We have seen. He's saying that the relevant date is the date of LOA. Even without going to the aspect of Gordhan Das, then also the question of whether it's a suppression to gain some advantage or a suppression which will not make any difference.
My lord, with all respect, I'll submit. Why this inquiry is being made? To test my bid capacity. End of the day, my lord, this exercise.
No, that part we may not agree with you. He says that suppression is good enough reason.
Okay.
Let suppression be good enough reason. But suppression, if we find that that is not touching on the mental element, having any intention to defraud or to make a false representation, then we may go to the second aspect.
I think, my lord, the relevant date would be the last date of submission of
bids.
If we go by.
You know, he says that the LOA was dated.
No, LOA will not determine the date, my lord. Last date of submission of date would be decisive. Because beyond that date, many things can happen. For example, my lord, Ashok Kumar Sharma's case, Lordship would recollect, where initial view of the Supreme Court was more the merrier. Because there the candidate did not pass. The Honorable Supreme Court said no. The relevant
Or
date
not
is
before the last date or no, here the word which he is citing, he says that LOA date is 10/3/2023, and therefore this LOA can be termed to be one of the works which you should have disclosed.
If a lordship would kindly come to page 385, my lord.
Yes.
Kindly come to clause 32.
Now we have seen the date of work
No,
order
not the
is
date, content, my lord. Kindly see the tender condition.
page.
Page 385.
Yes, yes.
Reply affidavit.
385. Yes, please.
Employer's right to accept any bid or to reject any bid or all the bids. This was in respect of that work, my lord. Notwithstanding clause 31, employer reserves the right to accept or reject any bid and to cancel the bidding process and reject all bids at any time prior to the award of the contract without thereby incurring any liability to the affected bidder or any obligation to inform the affected bidder or bidders of the grounds for the employer's action. Prior to the award of contract, my lord, not LOA. So here, my lord, it is prior to award of contract.
Okay. 18th.
Okay.
Okay.
So the present terms of the tender at page 55B, it provides that for the sake of clarification, it is mentioned that works for which the bidder has emerged as the winner of the bid, but LOA has not been issued as on the date before opening of the financial bid, shall also be considered while calculating value of bid.
That we have shown. That you have shown.
Well,
last-
where LOA has not been issued, even that is to be considered
For what? For what? Read further.
for calculation of the
Bid.
for
Value of the
calculation
bid.
for calculation of the value of bid capacity.
Ah.
So he has to disclose in the format. He has to disclose whatever wherever he has wherever he has become L1, even without LOA. But here is a case where LOA has been issued. I'll please direct.
18th,
Morning.
upon hearing Sri D. Nath, no, in continuation of the hearing held on 8/1/2024, comma, Sri D. Nath, the learned standing council, PWD, has made his submissions. Full stop. To adjudicate the dispute, comma, this court is of the opinion that the records pertaining to the impugned decision is required to be produced. More so in view of the fact that the affidavit of the department has disclosed certain more factors apart from those mentioned in the impugned minutes whereby the bid of the petitioner has been rejected. Full stop para. List on 18/1/2024 for production of the records. You make a mention on that day. Since records will be there, we'll try to finish this matter.
Yep.
Mr. Das, you are waiting for the whole day. What matter?
14 and 15 whether I am appearing for the settlement folder in item number 14 for the respondent number 7 and in the 15 whether item number respondent number 7, 6.
Okay.
Same settlement.
My lord, very short point is involved. I was the highest bidder, my lord. I have quoted 1.70 crore. And my
For
lord,
what?
for a market, my lord.
Which department? PNRD.
PNR.
Got the
PNRD.
records? Okay, very good.
But in the second case, my lord, we have not yet filed an affidavit. We have entered appearance. Your lordship directed in the last petition to serve us a copy of the petition. We have received the copy of it. We want to, my lord.
Let us decide the first case.
Yes.
If he's unsuccessful in the first case,
Yes.
then there will be occasion to hear the second case.
Yes.
If he's successful, then everything goes.
Yes. My lord will kindly come to
What is the name of the market?
page 41, my lord.
Name of the market?
Name of the market is
Mr. Chaudhary for 4757.
Bali Khotro bi-weekly market. Under Nagaon
4757.
Jila Porishad.
What is 4757?
I am in, my lord, 475.
Okay.
Bali Khotro, page 41 is the settlement order.
41.
You are hereby informed.
Just a minute. 41.
41. The vernacular is at page 42. English render translation is at
Okay, 41. 4757. 4757.
Yes.
This is Bali.
Khotro.
I think yearly settlement. 1 year.
Yeah.
You had moved this some time back, I think, Mr. Hussain. You said two cases are there. Okay, we remember. Okay, just a minute. Yes. Bali Khotro bi-weekly in Nagaon.
Yes.
Weekly in Nagaon, okay.
You are hereby informed that Bali Khotro bi-weekly market under Nagaon Jila Porishad is settled with you for the year 23.
Amran is a private respondent.
Yes. Respondent number 7.
Okay.
With effect from 1/7/23 to 36/24, at an amount of rupees 1 crore 52 lakhs for 12 months. Now, my lord, my rate is 1 crore 70 lakhs. Now, my lord, will kindly, this is the settlement order in favor of the respondent.
1 crore 52 lakhs. Okay. Main bit of. Annual bid was also 1 crore 52 lakhs.
My lord,
The
other
against,
with
no,
less than that.
no, what is that annual bid? No, last part, last line. For 12 months against annual bid value of, what is the meaning?
Bid value of 1 crore 52. That means estimated value was 1 crore 52 lakhs.
Same, his rate was at par.
At par.
Okay, and what was your
1 crore 70 lakhs, 18 lakhs more.
petitioner?
Yes,
How much? 1 crore?
70 lakhs. 18 lakhs more.
Okay. What is the reason?
No, my lord, the reason is not there. These are only the settlement order.
Comparative statement?
Yes, I'm coming. Page 43. My lord, 3 is the petitioner.
You are Mukhtar, you are
Yes,
Mukhtar.
I'm Mukhtar Hussain. And Amran Hussain Loscar is the respondent number 7.
Okay, 43.
Now, my lord will kindly see there are in several cases, columns, both of us did not issue submitted some documents. For example, debt clearance certificate, kindly see, my lord, both petitioner and respondent number 7 has not given. Then debt clearance certificate of guarantor also, both of them has not given.
Okay.
My lord, there is a background, lordship knows there is a clause in the tender that within
3
3
days,
days,
3
it should,
days.
that your lordship has stayed in another proceeding. My lord, this aspect was not made known to us. We are not aware of this judgment. Otherwise, my lord, we would have given. Now, my lord, kindly see serial number revenue that has not been given. Then
Three-
bank guarantee also, my lord,
That's 3
kindly see.
days, I think, 3 days, we think we have upheld, I think.
Now, finally, my lord.
At least this court has upheld, I think.
No, initially, there was a stay order.
No, one case we have decided.
No, not in connection with this case.
No, no,
Generally, that
general-
clause, generally that
I think this court has decided that
upheld.
upheld.
Then all the more necessary, my lord. Then they should get, now they within 3 days from that day, not today.
No, what is it? What is it then?
Yes.
Some factors, some fulfillment you could not do, they also could not do.
Yes, some relevant documents, my lord, because we are under the impression that it can be given within 3 days.
Okay.
Only because of your lordship's order, they refused to take it. Then kindly see, my lord, bank guarantee was also not given by both.
Then why did you choose him?
Yes, but the state
Mr.
government must
Devnath?
disclose.
Devnath? Where is the minutes? No, here in this writ petition.
In the writ petition, my lord, minutes we could not annex, my lord. We only got the. And there is a suppression from the side of the respondent number 7, which the authority have ignored.
Minutes, okay.
They have made
Commitment,
false statement on oath. They have filed false affidavit. They have given wrong information regarding ownership of land. They have also suppressed the fact that they were earlier lessees. All these aspects were ignored by the my lord authority.
Want to be incomplete. Only. No. Fixed deposit, no. Outside of that, no. Revenue, expense, no. Revenue, guarantor, no. Bank guarantee, no. Mr. Devnath, if we may uphold your decision not to give him, but why have you given him? Even he is defaulting in documents. If the clause which you have made applicable for rejecting the bid of the petitioner, that there is, though there is a clause of 10, there is some restriction, order restriction by the High Court, so we cannot give it to him. So it will be, you cannot apply and only to him. You do it afresh. Do it afresh for the
yes.
remaining period.
For remaining period, yes.
Remaining period. What is the final regarding that clause 10? No, not interim order.
There's no interim order.
There are final orders. আমি যে পঞ্চায়তৰ ক্লজ 10 to 3 দিন থাকাটো হেৰি বুলি ক'লো নেকি, ভ্যালিড বুলি ক'লো নেকি, 3 দিনত দিব পাৰে নেকি ক'লো, 3 দিন। Which decision are you having? You are Asadud Zaman.
Yes.
No, that I think is disposed of. We have disposed of one case. No, on clause 10, 3 days. Why don't you remember? You are a standing counsel, you should know these are very relevant matters. No, there is one case.
Which is? Oh,
And initially also, my lord, that there is a stay of that particular clause that they should have notified, in which case you would not have acted on this.
Just a minute, we might have. Now we'll do one thing, since documents are lacking on both the parts, we set this aside and give them a reasonable, not a very long time, around a week's time, and complete it.
Well, one thing you asked me, please.
Yes.
See. Well, the Mukhtar Hussain, the writ petitioner, and the second writ petitioner, well, Raisuddin, they are uncle and nephew. And the guarantor, your lordship, please find in column number 9, it is 9.
Yes.
Abul Qasim.
Abul Qasim, yes.
And he could not, while Amran Mukhtar Hussain could not give anything, document. But in case of Raisuddin Ahmed,
yes,
all the documents were given.
Yes.
Is same guarantor, Abul Qasim.
No, but how do you overcome your drawback? See, revenue, debt clearance certificate from guarantor, revenue, not there.
Revenue research, my lord, is not a requirement of the revenue of the NIT.
Debt clearance certificate own, not required.
Debt clearance certificate will do.
Own, but revenue.
That will do.
No, it's not there. No. Bank guarantee, no.
Bank guarantee is not required because the guarantor is there.
Then last, What about the debt clearance certificate own?
আছে forward.
We have given the certificate.
Not given, not given.
Sorry, yes. Yes.
The third is no. Revenue is no.
Revenue is not required.
Let us see the tender conditions.
Is 37, my lord. Clause 14.
37, 37.
Page 37 in vernacular, নিবিদাকারী
অথবা জামিনদাৰৰ
জামিনদারত নিবিদামূল্যৰ ওপৰত মাটি জমিন হিচাপে দিব লাগিব। জমিন দিয়া মাটিৰ চলিত বৰ্ষৰ জমাবন্দী উক্ত মাটি সকলো দিশৰ পৰা দায়মুক্ত প্ৰমাণপত্ৰ মাটি মূল্যৰ প্ৰমাণপত্ৰ সংশ্লিষ্ট উপায়ুক্ত মহকুমাধিপতি ৰাজচক্ৰ বিষয়ৰ পৰা নিবিদাৰ লগত কাটি দিব লাগিব। নিবিদাত জামিনদাৰেও চহী কৰিব লাগিব। মাটিৰ নথি পাতিৰ পৰিৱৰ্তে নিবিদা মূল্যৰ ওপৰত বেংক গেৰাণ্টি তথ্যও জামিন হিচাপে গ্ৰহণযোগ্য হ'ব। উক্ত মাটি অন্য এজন বজাৰ ঘাট মিনমহল পাউণ্ডৰ বাবে জামিন হিচাপে দিব নোৱাৰিব। এজনে জামিনদাৰ নিবিদাকাৰীয়ে অন্য এখন বজাৰ ঘাট মিনমহল হ'ব নোৱাৰিব, জামিন হ'ব। That means in respect of one plot of land, he can be either guarantor or only in respect of one.
Yes. Here,
This is the clause.
Here the guarantor was Abul Hussain in case of full petition. In one case.
No, is there any bar? Ultimately,
Yes.
one will get. There is no bar. Guarantor can be one. He'll be guarantee if the settlement is given to him.
But my lord, in one case, the documents were given. In the other case, the documents were not. And he's taking a plea now that within 3 days it could be verified.
That's the clause, not a plea.
Paragraph 6 of the writ petition.
My lord will kindly see clause number 17, my lord.
17.
17. প্ৰথম আৰু দ্বিতীয় খণ্ডৰ 1 নং দফাৰ পৰা 16 নং দফালৈ সন্নিবিষ্ট চৰ্তাৱলী পূৰণ নহলে নিবিদা বাতিল কৰা হ'ব। In our case, it has been done. And kindly see the, my lord, bid 18 lakhs more government would have got. I've got 1.7. His fees was at
Okay,
par.
heard. Sri K.N. Chaudhary, learned senior counsel for the petitioner in WPC 4757 of 2023, assisted by Sri A.D. Chaudhary, comma, Sri M.K. Hussain, learned counsel for the petitioner in WPC 7469 of 2023, full stop. Also heard Sri N.K. Devnath, learned standing counsel, PNRD department, whereas the private respondent in both these cases are represented by Sri B.C. Das, learned senior counsel assisted by Sri D.A. Kayum. Full stop. Para. No, para. Sri Devnath, the learned standing counsel, has also produced before this court written instructions as well as copy of the resolution adopted in the meeting held on 23/6/2023, containing the impugned decision. Full stop. Para. The matter pertains to settlement of the Bali Khotra BALI SATRO bi-weekly market in the district of Nagaon, which was published through a tender notice dated 29/4/2023. Full stop. It is the case of the petitioners that pursuant to the aforesaid tender notice, they had participated in the same and submitted their respective bids. Full stop. They had also relied upon clause 10 of the tender notice, as per which certain documents, in the event their bids were found to be the highest, they would be afforded 3 days time to submit those documents. Full stop. The petitioner, Sri Chaudhary, the learned senior counsel for the petitioner Mukhtar Hussain, has submitted that the price offered by him is rupees 1,70,00,000, 1 crore 70 lakhs. Whereas the offer of the private respondent is for an amount of rupees 1,52,00,000, 1 crore 52 lakhs. Full stop. The petitioner in WPC 7469 has made an offer of rupees 1,38, 1 crore 38 lakhs. Full stop. Para. It is submitted on behalf of the petitioners that strictly, if the documents offered by the respective parties are strictly examined, it would be revealed from the comparative statement that both the private respondent and petitioner Mukhtar Hussain did not fulfill all the requirements of submitting documents. Full stop. However, it is submitted that when the tender condition itself provided a leverage, provided for granting 3 days period to submit the documents, it was obligatory on the part of the respondent authorities to make an assessment of the price bids for those tenderers who otherwise have fulfilled the requirement of the tender conditions. Full stop. Para. It is further submitted that in matters of distribution of state legitimacy, which are meant for fetching revenue, the price offered by a party is a relevant factor which cannot be ignored and is not liable to be ignored. And the difference in the price offered is rupees 18 lakhs. Full stop. Para. Sri Devnath, the learned counsel for the petitioner, for the learned standing counsel of the department, has, however, justified the impugned decision by submitting that clause 10, which has been relied upon on behalf of the petitioner, was put on hold by a judicial order, and therefore the bid of the petitioner was not considered. Full stop. The impugned, the minutes of meeting dated 23/6/2023, a copy of which has been placed on record, however, does not state anything with regard to the deficiency of the bid of the private respondent. Full stop. Para. Sri B.C. Das, London Senior Counsel for the private respondent, has however submitted that the bid of his client was the highest, was the valid highest bid, as there was no deficiency in submission of the relevant documents, full stop. He further submits that for documents wherein there is a comment of non-submission are not relevant documents, and therefore no fault can be attributed with the impugned decision to settle the market in question with the petitioner, which has been done through the impugned order dated 30/6/2023. Full stop. Para. Upon hearing the rival contentions and on perusal of the materials on record, comma, the comparative statement of the respective bids would disclose that though the petitioner had though certain documents appear not to have been submitted by the petitioner with the bid, comma, there is also deficiency on the part of the private respondent who has been offered the settlement, full stop. The petitioner has given an explanation that clause 10 of the tender conditions would not permit rejection of a bid per se when all other documents have been submitted by the petitioner, and in respect of only those documents which comes within the purview, which are covered by the aforesaid clause, have not been submitted. Full stop. It is also submitted that the petitioner was not made aware of the fact that that the authorities would not take the relevant clause 10 into consideration because of some court's order. Full stop. Para. Be that as it may, comma, this court has noticed that deficiency in documents are there both in the bids of the petitioner, in petitioner Mukhtar Hussain, as well as the private respondent. Full stop. The difference in the price offered, which is rupees 18 lakhs, cannot be termed to be a minor difference, especially in matters of distribution of state legitimacy, in which which are meant primarily to fetch revenue for the state. Full stop. Para. In the case of this court, in the case of so-and-so, has held that in matters of distribution of state legitimacy, which are meant for fetching revenue, comma, the price offered is of paramount importance. Full stop. Para. Under the aforesaid facts and circumstances, comma, this court is of the opinion that interest of justice would be met if the authorities are directed met by directing the authorities to redo the exercise of settlement by giving the petitioners and the respondent to make good any deficiency in their documents within a period of when?
Within 7 days,
Within a period of 7 days.
from the requisition by the authority.
Within a period of 5 days from the date when the authorities would notify. Full stop. Consequently, comma, the impugned settlement order dated 30/6/2023 is set aside and a fresh settlement be offered to the valid highest bidder in accordance with law. Full stop. It is also observed that since the settlement period is for a period is for 1 year, comma, the aforesaid exercise be undertaken and completed within a period of how many? 3 weeks from today. 3 weeks from today.
Page 49, my lord, that clause is stayed, that case is pending still. As page 49. 49. WBC.
Stay affiliate, yeah.
This case is still pending for. Yes, pending. Paragraph 18 of that document, interim order. Page 58. Page 58, paragraph 8.
Yes. This, I think this was the
Already written.
4377 is our decision, I think. At page 52.
Yes.
4377. Because that case has been decided.
17,523.
Yes.
Then 6/9/01, 02, 2020-21.
Yes.
Upheld the validity of the clause.
Therefore, the direct.
Therefore, this court, at coordinate bench, will consider all the cases, and thereafter came second.
Okay, irrespective of this clause, you get some opportunity, both of you.
Yes, yes.
We have not said anything about that clause now. Your uncle will get. Mr. Das, he says, Hussein says that he's the highest bidder. But his uncle will get now. Nephew will not get.
Diplomat.
But one thing, well, only one thing. In column number 9, caste certificate.
Caste is
page
not
43,
required.
It is not there.
Not
Nobody is
required, not required.
there. Revenue, my lord, your lordship may only record my submission. That a revenue document is not required.
We have already said, those are not relevant.
That
We
is
have
that.
said. We have recorded. From data, 3 weeks from the date of receipt of the copy of this certified copy of this. Give a certified copy, Mr.
Yeah.
Chaudhary. Yes.
Both the petitions are
Dispose
disposed
of, yes. Both the petitions according to this can dispose of.
16. Yeah, please. This matter is relating to settlement of Pargha.
Again, 1 year.
1 year, term lordship. We have challenged the order lordship, that is page 43.
33.
43.
Okay.
That has been issued by the CEO, Jila Parishad, without,
6 is complete.
my lord.
R6 is complete.
Yes, lordship. That is order dated 4/12/2023.
Anyone appeared?
Nobody is appearing, lordship. We have
412.
in respect of respondent, private respect.
Okay, 412. Good, very good. Yes.
Order lordship is at page 43,
The settlement order.
my lord.
4-3.
43.
Yes, please.
In pursuance of resolution number so General Standing Committee meeting held on so and consequence upon deposit of total amount of rupees so only being the negotiated value so Pargat is settled with Anwarul Islam so for the year 2023-24 under the following council.
What is the name? Khugram
Gugra Kandi Pargat.
Khugra Kandi. Where is it? Hatsingimari.
My lord, South Salmara. My lord, our challenge is basically on the ground that this
order was issued without any tender. And so Jila Parishad Lordship, CU has no jurisdiction unless and until this tender process is issued by the Anchalik Panchayat. It should be floated from the Lordship Anchalik Panchayat. And in the after Lordship submitting the bid value, if the Anchalik Panchayat found that the bid value is more than ₹1 lakh, then it will go to Jila Parishad. Only after that the Jila Parishad has the jurisdiction.
But here the value is 1 lakh, more than 1 lakh.
No, that is the negotiated value, not the bid value.
Bid value was what? Less than
No,
that?
there was no tender process.
No tender process?
No tender process. That is our case law. Initially, tender NIT was issued. The Lordship, I have annexed that NIT, but nobody has offered any tender. And in respect of the this
NIT is dated?
Lordship dated 4/5/2023. Case 13 Lordship.
And if NIT was issued, how can you contend that there was no process of tender?
No, that was Lordship. Why I am saying Lordship? No, in the NIT was issued in respect of 12 Parghat, Hart and Parghat. All other Lordship, Parghat Lordship, bid value was offered only in respect of this Parghat Lordship. Nobody has submitted any tender. I have annexed that comparative statement also Lordship from case Lordship 23-1. In respect of this Parghat,
You are Momimur Islam?
my lord.
Where is it? It's compared notice. You have cancelled? You have cancelled it?
What
over?
happened, Madam, the Anchalik Panchayat did not submit a comparative. My lord, we have a look at the paragraph comment, paragraph 4. 3, 4, 5, 6. And 7.
What is this order? What is your...
What has happened, my lord? This is actually an order suspending the person who had actually issued an order whereby the petitioner was
allowed temporarily
allowed to
run
actually collect toll.
He was allowed to correct order.
He was actually allowed by a person named
390.
Profiel Hawk, who is the tax collector. He couldn't have done it, man. He had no authority.
Not for that, I am basically on the jurisdiction of the Anchalik. We want plus settlement through tender process.
Let us see your pleadings.
I am not to that case. That's okay.
5. Officer. Was there any very tender process for this ghat?
There was one. What happened was that the Anchalik Panchayat did not submit any compared with Tapper. Thereafter, what happened, my lord? The standing committee, general standing committee, they had a meeting. That what happened before that? Annual my lord, Islam yet submitted an application petition offering payment of revenue of 1 lakh. This is mentioned paragraph. And for the year 2020.
But aren't you required to give an opportunity to all concerned? You have to. But you are also beneficiaries of illegal activities.
I am not insisting on that part. But
No, but we are insisting. You are in a writ court, code of equity.
That is,
You took benefit.
my prayer is only to settle the heart with tender.
But why should we do it at your instance? Let somebody, a better person come.
Better person that will determine in the tender. But
A
not
better
in-
person, eligible person. You took activities and you are the beneficiary of activities. The person who had given you the settlement order was without any authority. Tax collector gave you the.
I have no any prayer lordship to that effect that I should be allowed to continue with the.
We are asking, who are you? What is your locus?
But I am the aspirant lordship.
Aspirant, you had already taken benefit illegally. But you should take a valid process. We may not grant his prayer, but you cannot settle a matter. One illegality, you cannot replace the another illegality. When is it coming to an end?
So 10 till 30 June 2020.
Period is going to get over.
You said that you had offered 1 lakh, 1 crore 70. Oh, sorry.
That's 14 times of the previous.
Did you submit your bid pursuant to the NIT of 4523?
No, lordship, I was not available at that time.
Then how can you question?
So the retender process can.
Now,
be-
how can you question? You are not even a tenderer.
That is there, but
Good case, very good case, but not at your behest. First instance also you could have ignored. Yes, you took benefit of some illegality, but you had participated. Now that's not brought to the logical conclusion. Heard. Sri M. Khan, Learned Counsel for the petitioner. First of all, also heard Sri N. K. Devnath, Learned Standing Counsel, Panchayat and Rural Development Department. Full stop. The subject matter pertains to the settlement of Gurgurkandi Parghat under the Fekamari Anchalik Panchayat in the district of South Salmara, Mankachar. Full stop. Para. It is submitted by Sri Khan, the Learned Counsel, that do a notice dated 4/5/2023 was issued inviting bids for various parghats, including the present one, there was no, as per the petitioner, nobody had submitted any bids. Full stop. However, vide the impugned order dated 8/8/2023, the Ghatun question has been settled in favor of the respondent number 6. Para. This court vide order dated 4/12/2023 had accepted the office note dated 1/12/2023 regarding completion of service upon the private respondent. Full stop. For private respondent who has chosen not to appear and contest. Para. it is submitted that settlements can be done only through a validly concluded tender process, and accordingly, the impugned order of settlement dated 8/8/2023 is liable to be set aside. Full stop. Para. Par contra, comma, Sri Devnath, the Learned Standing Council, has raised two basic issues questioning the locus of the petitioner to maintain the present challenge. Full stop. Para. Firstly, it is contended on behalf of the department that the petitioner of this case was himself the beneficiary of an illegality by which he had operated the Parghat in question from 13/2/2023 to 36/2023. Full stop. Though, as per the pleadings made in the writ petition, comma, such settlement was done by the executive officer, comma, Fekamari Anchalik Panchayat, by the order dated 10/2/2023, comma, this court has been apprised that the order was issued by fraudulent means. Full stop. Sri Devnath has in fact placed on record a copy of the order dated 6/1/2024 by which the concerned employee of the office of the Chief Executive Officer, Fekamari, employee of the office of the Fekamari Development Block, has been placed under suspension for fraudulently issuing such an order. Full stop. Para. Secondly, it is submitted that the petitioner did not even offer his bid pursuant to the NIT dated 4/5/2023, and therefore he is not he would not have the locus to raise any dispute with regard to the consequent settlement. Full stop. Para. Though distribution of state legacy is required to be done in a transparent and fair manner, comma, in the instant case, the objections raised on behalf of the department are substantial in nature, where the petitioner himself was the beneficiary of an illegality in having the benefit of the settlement for the period 13/2/2023 to 36/2023. Full stop. Even if the though the aforesaid aspect is a relevant aspect for a writ court which exercises powers of equity, comma, the fact that the petitioner was not even a bidder pursuant to the NIT dated 4/5/2023 will preclude him from raising any issues with regard to the subsequent settlement. Full stop. In that view of the matter, comma, without going into the merits of the settlement order, comma, the instant writ petition is rejected on preliminary grounds. Full stop. Otherwise, you don't endorse your decision. You have to have a NIT. Had somebody else said, come, we would have definitely interfered. You ask your persons to get it done properly.
Item 17.
Oh, hey, no, I would go to 17.
It-
Oh, yes, yes.
After the inspection was direct inspection, revenue.
Hmm. Today it might not be possible. Tomorrow we'll have it. Tomorrow.
Yes.
What is your instruction?
But my that was 61.
You are supporting the petitioner.
No, Lord, it's as per my instruction.
What?
I'm stating
No, no.
my
It is seen that the possession of the land as shown by the writ petitioner falls under Doc 16,
Yes.
old, and 162 new,
That certificate I have.
which is not related to any old Doc of 26.
they have found any duck number. Wait, it's
So what was your earlier Doc number?
Earlier number 16, my lord.
So,
It is there, my lord, there is certificate.
Mr. Nayak?
When I first.
Have-
Number,
No, in possession.
yeah. In position 68 in our, then if it's 162. That is because
62, my lord,
one benefit is one. Present duck. This is for present.
No, the Doc number 16 old, what
Old.
was it?
Old is
Certificate
resident.
was that old duck. But in our map, that's what's residence. But 162, even at that position of time of our position was same as 162.
No, but Revenue Department has in clear terms said that this land, which is the subject matter, is not related to any old Doc number of 26.
Not- This is our location is 160. This is position 160.
26 is Pattanam. 26 is Pattanam.
That's still not 160.
Tomorrow we'll decide.
Yes. At Pattanam.
Paucity of time, huh? List again. Tomorrow, is it okay? Tomorrow, Friday, then go.
12
Huh?
o'clock, my lord.
Huh?
12 o'clock.
Well, no, we
Take-
cannot, we
It
cannot,
will take
we
because
will
my
not
lord,
fix that.
rainy season is coming. There are
We'll not,
typical-
we'll not fix any time, cannot fix any time.
Yes.
We'll have it tomorrow. If
I'll
it's
be-
possible, we're done only. Otherwise, cannot give any preference.
That may be kept as a record, my lord. That I have
No,
Namdar
no,
certificate.
that we have.
Namdar
We
certificate.
produce it tomorrow again.
Okay.
Right.
Hello, next item. That may fix for water and last page.
Which one?
Item number 18. ma'am. So the change should be there already. 8th of February.
8 February, okay, 8 February interim order.
Till then, my lord, interim order.
Is extension, 8 February.
My lord, I want to make a mention for item number 20.
Yes,
My lord, it may be fixed on 7th of February.
okay. 7 February. Interim order. No interim order.
For item number 20, ma'am.
Yes.
Because an urgent matter, my lord, maybe tomorrow would not be possible.
What is the matter about?
This is the demarcation of the boundaries of the panchayat, fisheries of the panchayat. Justice service was issued, we have complied with the,
Okay, have a date of your choice. Which
my lord,
date?
18th of Jan.
18, no, don't, not 19. Have it on 22nd. 22nd. Huh? Is there an interim order? No interim order.
So, my lord, can we have it on 23rd, ma'am?
23rd, okay, 23rd. 23rd, no, Tuesday, difficult. 24th then.
24.